Yeah, this is my book here. Back on record in C-377-407. Mr. Davis is present with Mr. Sam. Anything we need to address outside the presence of the jury at this time?
Ms. Davis.
Okay, we'll bring them in, read instructions, and then I'll hand it over to you guys for closings. Ready to bring in the jury?
Oh, I'm sorry.
Oh,
Before we do that,
hang on.
You gotta check that line of instruction.
That was put in.
Yeah, I just want to make sure that 44 is the replaced instruction that we have.
The credibility or believability, the standard credibility or believability, not the pattern. Got it. The one that you requested.
Thank you.
We've got it. All right, I think we can bring them in now. Please rise for the jury, everyone.
Oh, listen to California Love this in a month. It's the clean laptop.
Do the parties stipulate to the presence of the jury?
Yes, sir. Yes, sir.
You may be seated. All right, welcome back, ladies and gentlemen. We're now on to the part of the case where I read you the instructions on the law that apply to this case. I've been told that I read fast, so I'm going to read the instruction number before I read the actual instructions, so please write it down if that's something that you think you'll want to revisit. Additionally, you will have plenty of copies in the jury room with you when you go back to deliberate. All right, without further ado, let's get started on the jury instructions. 1. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. 2. If in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. 3. An indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged in an indictment that on or about the 7th day of September 1996, the defendant committed the offense of murder with use of a deadly weapon within the county of Clark, state of Nevada, contrary to the form, force, and effect of statutes in such cases made and provided, and against the peace and dignity of the state of Nevada. Did willfully, unlawfully, and feloniously, and knowingly, for the benefit of, at the direction of, or in affiliation with the criminal gang, to wit, Southside Compton Crips, with malice aforethought, kill Tupac Amaru Shakur, a human being, with use of a deadly weapon, to wit, a firearm, by shooting at and or into the body of the said Tupac Amaru Shakur, said killing having been willful, deliberate, and premeditated, the defendant being criminally liable under one or more of the following principles of criminal liability, to wit: 1. Directly committing this crime, and or 2. Aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime. To wit, defendant obtaining a firearm for the purpose of seeking retribution against Tupac Amaru Shakur and or Marion Knight, a.k.a. Suge, and while in a vehicle with Terrence Brown, a.k.a. Bubble Up, and or DeAndre Smith, a.k.a. Big Dre, and or Orlando Anderson, a.k.a. Baby Lane, did provide said firearm to DeAndre Smith, a.k.a. Big Dre, and or Orlando Anderson, a.k.a. Baby Lane, with the intent that said co-conspirators commit said crime, and or 3, pursuant to a conspiracy to commit the crime, with the intent that this crime be committed, defendant and or Orlando Anderson, aka Baby Lane, and or DeAndre Smith, aka Big Dre, and or Terrence Brown, aka Bubble Up, aiding or abetting and or conspiring by acting in concert throughout. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of the offense charged. 4. A conspiracy is an agreement between two or more persons for an unlawful purpose. To be guilty of conspiracy, a defendant must intend to commit or to aid in the commission of the specific crime agreed to. The crime is the agreement to do something unlawful. It does not matter whether it was successful or not. A person who knowingly does any act to further the object of a conspiracy or otherwise participates therein is criminally liable as a conspirator. However, mere knowledge or approval of or acquiescence in the object and purpose of a conspiracy without an agreement to cooperate in achieving such object or purpose does not make one a party to conspiracy. Conspiracy is seldom susceptible of direct proof and is usually established by inference from the conduct of the parties. In particular, a conspiracy may be supported by a coordinated series of acts in furtherance of the underlying offense, sufficient to infer the existence of an agreement. A conspiracy to commit a crime does not end upon the completion of the crime. The conspiracy continues until the co-conspirators have successfully gotten away and concealed the crime. 5. It is not necessary in proving a conspiracy to show a meeting of the alleged conspirators or the making of an express or formal agreement. The formation and existence of a conspiracy may be inferred from all circumstances tending to show the common intent and may be proved in the same way as any other fact may be proved, either by direct testimony of the fact or by circumstantial evidence, or by both direct and circumstantial evidence. 6. Each member of a criminal conspiracy is liable for each act and bound by each declaration of each other member of the conspiracy if the act or the declaration is in furtherance of the object of the conspiracy. The act of one conspirator pursuant to or in furtherance of the common design of the conspiracy is the act of all conspirators. Every conspirator is legally responsible for a specific intent crime of a co-conspirator so long as the specific intent crime was intended by the defendant. A conspirator is also legally responsible for a general intent crime that follows as one of the reasonably foreseeable consequences of the object of the conspiracy, even if it was not intended as part of the original plan, and even if he was not present at the time of the commission of such act. 7. If one member of a conspiracy withdraws from the agreement before an overt act in furtherance of the conspiracy's target crimes has been committed by any members of the conspiracy, the withdrawing member is not responsible for the future crimes of his or her co-conspirators. Withdrawal from a conspiracy requires the following elements. 1. That the defendant completely withdrew from the agreement. A partial or temporary withdrawal is not enough. 2. That the defendant took affirmative steps inconsistent with the objectives of the conspiracy to disavow or defeat the objectives of the conspiracy. 3. That the defendant made a reasonable effort to communicate those acts to his co-conspirators, or that he or she disclosed the scheme to law enforcement authorities. And 4. That the defendant withdrew before any member of the group committed an overt act in furtherance of the conspiracy. An affirmative step would include an act that is inconsistent with the purpose of the conspiracy and is communicated in a way that is reasonably likely to reach the other members. But some affirmative step is required. A mere cessation of activity in the conspiracy, or just avoiding the other members of the group, is not sufficient to withdraw. 8. Evidence that a person was in the company or associated with one or more other persons alleged or proved to have been members of a conspiracy is not, in and of itself, sufficient to prove that such person was a member of the alleged conspiracy. However, if you are instructed that the presence, companionship, and conduct before, during, and after the offense are circumstances from which one's participation in the criminal intent may be inferred. 9. Where two or more persons are accused of committing a crime together, their guilt may be established without proof that each personally did every act constituting the offense charged. All persons concerned in the commission of a crime who either directly and actively commit the act constituting the offense, or who knowingly and with criminal intent aid and abet in its commission, or, whether present or not, who advise and encourage its commission with the intent that the crime be committed, are regarded by the law as principals in the crime thus committed and are equally guilty thereof. A person aids and abets the commission of a crime if he knowingly and with criminal intent aids, promotes, encourages, or instigates by act or advice, or by act and advice, the commission of such crime with the intention that the crime be committed. The state is not required to prove precisely which defendant actually committed the crime and which defendant aided and abetted. 10. Murder in the first degree is a specific intent crime. Defendant cannot be liable under conspiracy and or aiding and abetting theory for first-degree murder for acts committed by a co-conspirator unless defendant also had a premeditated and deliberate specific intent to kill. Murder in the second degree may be a general intent crime. As such, defendant may be liable under conspiracy theory and or aiding or abetting for murder of the second degree for acts committed by a co-conspirator if the killing is one of the reasonably foreseeable consequences of the object of the conspiracy. 11. In this case, the defendant is accused in an indictment alleging an open charge of murder. This charge may include murder of the first degree or murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. 12. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. 13. Malice aforethought means the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from any unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. 14. Express malice is that deliberate intention unlawfully to take away the life of a human being, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears or when all the circumstances of the killing show an abandoned and malignant heart. 15. Murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All three elements, willfulness, deliberation, and premeditation, must be proven beyond reasonable doubt before an accused can be convicted of first-degree murder. Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the action. A deliberate determination may be arrived at in a short period of time, but in all cases the determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. Premeditation is a design, a determination to kill, distinctly formed in the mind by the time of the killing. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. 16. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. 17. Although your verdict must be unanimous as to the charge, you do not have to agree on the theory of liability. Therefore, even if you cannot agree on whether the facts establish the defendant is liable as a principal, aider and abettor, or co-conspirator, so long as all of you agree that the evidence establishes the defendant's guilt of murder in the first degree, your verdict shall be murder of the first degree. 18. You are instructed that if you find the state has established that the defendant has committed first-degree murder, you shall select first-degree murder as your verdict. The crime of first-degree murder includes the crime of second-degree murder. You may find the defendant guilty of second-degree murder if 1. You have not found beyond a reasonable doubt that the defendant is guilty of murder of the first degree, and 2. All 12 of you are convinced beyond a reasonable doubt that the defendant is guilty of the crime of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt as to whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder in the second degree. 19. All murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation. 20. The killing of another person in self-defense is justified and not unlawful when the person who does the killing actually and reasonably believes 1. There is imminent danger that the assailant will either kill him or cause him great bodily injury, and 2. It is absolutely necessary under the circumstances for him to use in self-defense force or means that might cause the death of the other person for the purpose of avoiding death or great bodily injury to himself. 21. A bare fear of death or great bodily injury is not sufficient to justify killing. To justify taking the life of another in self-defense, the circumstances must be sufficient to excite the fears of a reasonable person placed in a similar situation. The person killing must act under the influence of those fears alone and not in revenge. 22. An honest but unreasonable belief in the necessity for self-defense does not negate malice and does not reduce the offense from murder to manslaughter. 23. The right of self-defense is not available to an original aggressor, that is, a person who has sought a quarrel with a design to force a deadly issue, and thus through his fraud, contrivance, or fault, to create a real or apparent necessity for making a felonious assault. However, where a person without voluntarily seeking, provoking, inviting, or willingly engaging in a difficulty of his own free will is attacked by an assailant, he has the right to stand his ground and need not retreat when faced with the threat of deadly force. 24. Actual danger is not necessary to justify killing in self-defense. A person has a right to defend from apparent danger to the same extent as he would from actual danger. The person killing is justified if 1. He is confronted by the appearance of imminent danger, which arouses in his mind an honest belief and fear that he is about to be killed or suffer great bodily injury, and 2. He acts solely upon these appearances and his fear and actual beliefs, and 3. A reasonable person in a similar situation would believe himself to be in like danger. 25. The killing is justified even if it develops afterwards that the person killing was mistaken about the extent of the danger. 26. If evidence of self-defense is present, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. If you find that the state has failed to prove beyond reasonable doubt that the defendant did not act in self-defense, you must find the defendant not guilty. 27. If a person kills another in self-defense, it must appear that the danger was so urgent and pressing that, in order to save his own life or to prevent his receiving great bodily harm, the killing of the other was absolutely necessary, and the person killed was the assailant, or that the slayer had really and in good faith endeavored to decline any further struggle before the mortal blow was given. 28. You are instructed that if you find the defendant guilty of first or second degree murder, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond reasonable doubt that a deadly weapon was used in the commission of the crime, you shall return the appropriate guilty verdict reflecting with use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. 29. Deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. A firearm is a deadly weapon. 30. The state is not required to have recovered the deadly weapon used in an alleged crime or produced the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. 31. If more than one person commits a crime and one of them uses a deadly weapon in the commission of that crime, each may be convicted of using the deadly weapon even though they did not personally himself or herself use the weapon. An unarmed offender uses a deadly weapon when the unarmed offender is liable for the offense. Another person liable to the offense is armed with and uses a deadly weapon in the commission of the offense, and the unarmed offender had knowledge of the use of the deadly weapon. 32. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to approve a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. 33. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond reasonable doubt every element of the crime charged, that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but it's such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. 34. You are here to determine if the defendant is guilty or not guilty based on the evidence in the case. You are not called upon to return a verdict as to the guilt of any other person. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. 35. The evidence you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any exact facts admitted or agreed to by counsel. There's two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulates the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court or any evidence stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must be disregarded. 36. It is a constitutional right of a defendant in a criminal trial that he may not be compelled to testify. Thus, the decision as to whether he should testify is left to the defendant and the advice and counsel of his attorney. You must not draw any inference of guilt from the fact that he does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. 37. You have heard evidence regarding drug trafficking, federal convictions, and gang affiliation of defendant. This evidence was not offered to show propensity of defendant to commit crimes, and you may not consider this evidence for that purpose. You may only consider this evidence for the purpose of motive, identity, or the credibility of the defendant's statements. 38. A proffer agreement is a contractual agreement between a specific government entity and a defendant that obligates that specific government entity and that defendant to its terms, wherein both sides of the contract expect a benefit in exchange for entering into the contract. It does not bind any other specific government entity. In this case, you have heard that the defendant entered through counsel into an agreement with the United States government. The state of Nevada is not bound by that agreement. 39. A statement need not have been made by the defendant himself to be considered his own statement. If you find that the defendant, by his own words or conduct, manifested that he adopted a statement or believed it to be true, you may consider that statement as the defendant's own statement, the same as if he had made it himself. 40. Statements the defendant made during a police interview have been admitted in evidence. Such statements may be confessions, which are acknowledgments of guilt, admissions, which are acknowledgments, or admissions, which are acknowledgments of the existence of facts that tend to incriminate the defendant, or neither. If you determine any statement of the defendant made during the interview to be a confession or admission, you must first determine if the statement was voluntarily made. A confession or admission is not voluntary if it was coerced by physical intimidation or psychological pressure, such that the defendant's capacity for self-determination was critically impaired and his or her will was overborne at the time he or she made the confession or admission. Improper coercive police activity is a necessary predicate to finding that a confession or admission is not voluntary, and there must be a link between the coercive conduct and the defendant's confession or admission. A confession or admission is not rendered involuntary by moral or psychological pressures to confess emanating from sources other than improper police coercion. Police coercion does not include factors which motivate a person to speak because of self-interest or by the expectation of a benefit. 41. In making a decision about the voluntariness of a confession or admission, you should consider all the evidence about the statement, including the circumstances under which the defendant may have made it. Factors to be considered in determining whether a confession or admission was voluntary include 1. The youth of the accused, 2. His or her lack of education or his or her low intelligence, 3. The lack of any advice of constitutional rights, 4. The length of the detention, 5. The repeated and prolonged nature of questioning, and 6. The use of physical punishment such as the deprivation of food or sleep. The state has the burden of proving by a preponderance of the evidence the defendant's confession or admission to police was voluntarily made. To prove something by the preponderance of the evidence is to prove that it is more likely true than not true. This is a lesser burden than proof beyond a reasonable doubt. If you determine a confession or admission of the defendant was not voluntary, you may not consider it for any purpose. If you determine a confession of the defendant was voluntary, you may consider it like any other testimony or evidence in the case. 42. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given any admission or confession. 43. Whenever there is slight evidence that a conspiracy existed and that the defendant was one of the members of the conspiracy, then the statements and the acts by any person, likewise a member of the conspiracy, may be considered by the jury as evidence in the case as to the defendant found to have been a member of the conspiracy, even though the statements and acts may have occurred in the absence and without the knowledge of the defendant, provided such statements and acts were knowingly made and done during the continuance of such conspiracy and in furtherance of some object or purpose of the conspiracy. 44. The credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. 45. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight you deem it entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. 46. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. 47. During this trial, you have received into evidence certain audio recordings together with typewritten transcripts of those recordings to help you follow along and understand their contents. Keep in mind the recordings themselves are the evidence in the case. The transcripts are provided only as an aid to assist you in understanding the recordings. 48. In your deliberation, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of whether the state has proven that the defendant is guilty beyond a reasonable doubt. 49. When you retire to consider your verdict, you must select as one of your number to act as foreperson who will preside over your deliberation and will be your spokesperson here in court. During your deliberation, you will have all the exhibits which were admitted into evidence, these written instructions, and forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson and then return with it to this room. 50. If during your deliberation you should desire to be further informed on any point of law or again hear portions of the testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to court where the information sought will be given to you in the presence of and after notice to the district attorney and the defendant and his counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, carefully describe the testimony to be played back so the court recorder can arrange your notes. Remember, the court is not at liberty to supplement the evidence. If during your deliberation you should be desired to be further informed on any point of law or again hear portions of the testimony, you may send a note through the marshal, signed by one or more of you. No member of the jury should ever attempt to communicate with me except by signed writing, and I will respond to the jury concerning the case only in writing here in open court. If you send out a question, I will consult with the lawyers before answering it, which may take some time. You may continue your deliberations while waiting for the answer to any questions. Remember, you are not to tell anyone, including me, how the jury stands, numerically or otherwise, on any questions submitted to you, including the question of the guilt of the defendant, until after you've reached a unanimous verdict or have been discharged. 51. During deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. 2, read, watch, listen to any news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. And 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. 52. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your mind the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole, fixed, and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. Given this 31st day of August, 2026, by District Court Judge Carly Ernie. All right. State, are you prepared to give your closing argument at this time?
Yes, sir.
You may proceed whenever you're ready, Mr. Kowal.
You folks got all that from the judge. About 2 weeks ago, exactly 2 weeks ago, I came before you and said this was a case about gang retaliation and revenge. Nearly 30 years ago, Orlando Anderson was beaten at the MGM Grand by Tupac Shakur, Suge Knight, and the group that he was with. And Orlando Anderson was somebody of consequence in the Southside Crips. And Duane Davis was the head of the Burr Street faction of the Southside Crips. And Duane Davis, in the culture of gangs, could not let that stand. And so what did he do? He acquired a firearm, got his group together, and went hunting for Mr. Shakur and Mr. Knight. They went to Club 662, they didn't find them. They go to a liquor store, decide to have some drinks. Then, in happenstance, they happen to run into Tupac and Suge Knight going the opposite way of they go. And in that moment, a decision is made. Not to keep going, but to make a U-turn, turn around, pass a gun, and shoot into the Tupac and Suge's car, killing Tupac Shakur. So, I know the judge went over about 52 jury instructions, and I want to go over a couple of them as well so we can kind of understand what we're talking about here. So the first one the judge went, and I kept the numbers up there in case you want to have them, is reasonable doubt. And what the law says is reasonable doubt is based on reason, which is not very helpful, at least I don't find it. But it also tells you what reasonable doubt is not. Doubt to reasonable must be actual, not mere possibility or speculation. And so when holding the state to its burden, you should absolutely be determining whether or not we've met the evidentiary threshold. But possibility and speculation is not reasonable doubt. There's a common sense instruction. It's number 46. And as you may recall, we spent about a week picking you folks to be part of our jury. And we asked a lot of questions. We asked whether or not you'd accept all kinds of evidence or require us to only have one type of evidence. We asked about what your knowledge of the facts in this case. We asked about your background. I think we even asked about what your favorite movie was. But the goal is to create a cross-section of our community. You all have different experiences, different knowledge, different ways of having dealt and processed with information. And moreover, you have different sense of common sense, right? Different sound sense of judgment. And what the goal here is, you don't have to pretend your judgment or your common sense doesn't exist just because you walk into this courtroom. You bring your common sense as a whole, your judgment as a whole, your personage as a whole when you come to this courtroom. One thing I think is very important to discuss is, in opening statement, Mr. Samt told you that you have to corroborate every word of the defendant's sentence in order to believe it. I think he even had a slide up there that said, I mean, not nonsense, but BS, I guess, right? BS. But that's not actually true. That's not the law. Jury instruction number 42 tells you what the law is. When independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statement, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to the crime. So this notion of corroboration, I will tell you, I think we'll discover that there is corroboration. But this notion of corroboration, the mandatoriness of corroboration, does not exist in the law. It is absolutely untrue and not part of our requirement.
I apologize, Your Honor. May we approach?
You may.
All right, so like I was saying, that the criminal agency of another, defendant's own statement, if believed, admitting the crime, need not be further corroborated by the evidence. So this hunt for corroboration that Mr. Santos put you on is not a legal requirement. But like what I told you is I think there is corroboration, and I think we'll talk about that as we go on. But the one thing we have to prove without corroboration is that somebody was killed by the act of another. We don't have to say who that person is. We don't have to corroborate who that person was. But we have to say somebody was killed by the act of another. And here we know Tupac Shakur's death was caused by the criminal act of another person. So we've met that threshold. And once we've made that threshold, no further corroboration is required. The last thing general instruction I want to talk to you about is direct versus circumstantial evidence. That's jury instruction number 35. And in this courthouse, we have an analogy that we frequently use to explain what direct versus circumstantial evidence is. So, if you were to go outside and you saw rain, that would be direct evidence, right? Mr. Davis's confessions are direct evidence of a crime. But there's also circumstantial evidence. So what is circumstantial evidence? Well, in that same analogy, let's say after a long day here at court, you go home. You go to your car, you go home, and you notice that there's dark clouds in the air, there's a little bit of humidity, the weather's a little bit cooler than you normally expect, and then you go inside to your house. Right? While going inside your house, you see the sidewalks are dry, the grass is dry, all of that stuff. You go to sleep, you wake up the next morning, and you notice that the ground is wet, the grass is wet, maybe your car is wet. That is circumstantial evidence that it rained. And so you have direct evidence, I saw it, I was there. And circumstantial evidence, those facts that exist that show something happened. And I will submit to you that this case is drenched with circumstantial evidence, even beyond Mr. Davis's statements. So I want to do a little experiment as we go through this. Let's, instead of focusing on Mr. Davis's statements, let's see what happens if we just throw all those statements away and see what we have. Because it seems like you've been told that there's nothing that exists outside of Mr. Davis's statements. And that is simply not true. So we heard from gang detectives that Compton was 10 square miles that had two gangs that are relevant to this case, Mob High Roots and outside of Compton Crips. Bobby Ladd told you that. And Reggie Wright Jr. and Mob James told you that Death Row Records had the head Suge Knight and one of its main artists, Tupac Shakur. And interestingly enough, we learned that there were two types of security, right? There's like a mob security and death row security. And the mob security, for our purposes, involved Mob James McDonald, his brother Alton Buntry McDonald, Roger Neckbone Williams and Trayvon Leonard. And that the more straight security, or official security, was Reggie Wright Jr. and Frank Alexander. And Frank Alexander was the person that was with Tupac Shakur the night that he was killed. We also know that the rival was Southside Compton Crips. We heard that from a lot of people outside of Mr. Davis. In fact, we heard from Bobby Ladd and Devontae Lee, Dirt Rock, say that Duane Davis was the leader of the Southside Compton Crips. You actually even heard Wade Lee, the detective who was investigating him on narcotics charge, say that he was the leader of the Southside Compton Crips due to his narcotics trade, that money was the lifeline of gangs. Bobby Ladd went so further to say he was the shot caller of the Southside Compton Crips. And Bobby Ladd is the person who could tell you that. He was the one working gangs in the 1990s in Compton. Moreover, since then, he's become an expert talking to people all around the world about the gangs of Compton, particularly the Crips and the Bloods. So outside of anything Mr. Davis has said, you can establish that he was a leader, a shot caller, and the narcotics trafficker. We also know through Devontae Lee and Bobby Ladd that Orlando Baby Lane Anderson was a member of the Southside Compton Crips, and also Duane Davis' nephew. In fact, Detective Dupree also tells you that Orlando Baby Lane Anderson was very close. He used the word prince of Southside, only behind Duane Davis. And then we also learned about the other members of the Southside Compton Crips. We learned about Terrence Bubble Up Brown, Corey C. Ray Edwards, who we did not get to show up. We learned about DeAndre Big or Freaky Dre Smith. We heard about Orlando Baby Lane Anderson. And then we had Devontae Dirt Rock Lee also testify here today. He told you about these folks, as did Bobby Ladd. We also learned about the connection between Keffe D and Eric Zip Martin. We learned about that through both Wade Lee, who did the narcotics investigation into Duane Davis, and we learned it through Bobby Ladd, who told you that he was assisting in federal investigations with Duane Davis and his connection with Zip Martin. And in fact, what Bobby Ladd had told you was that Duane Davis had gotten so high on the food chain that he wasn't somebody that Bobby Ladd would be investigating as a gang detective. That was more of an FBI, DEA type investigation. Through Mike Dorsey, we also learned about the connection between Sean Combs and Zip Martin. We also learned from Dirt Rock and from Reggie Wright Jr. and from Mob James that Duane Davis was providing some form of security for Bad Boy Entertainment. Now, this is not official security. This is just be around, make sure our guys are okay in case they run into mob guys. And we learned that from all those other witnesses, not a word from Duane Davis. And then we learned from all those witnesses that this developed into a rivalry that involved both gangs and music labels. Then we had the Lakewood Mall incident. Now, we've heard a lot of people talk about having heard about the Lakewood Mall incident, including Bobby Ladd and Reggie Wright Jr. and a number of other folks. But we actually heard from somebody who was there. We heard from Dirt Rock himself. He said there was 5 or 6, there was a number of mob guys there, there's a number of Southside Crips there, and there was a brawl inside the Foot Locker. And the brawl was so big that it caused a lot of damage inside the Foot Locker. And then we also learned that it was about a death row chain, or a death row chain was involved. We learned from both Devontae Lee and from Bobby Ladd that taking the chain was an ultimate sign of disrespect. Now let's talk about September 7th, 1996. What else do we know about September 7th, 1996 that doesn't involve Duane Davis' statement? Well, we know the Burr Street crew was in Las Vegas. We know at least 2 of them. Orlando Anderson, there's a receipt for him at the Excalibur Casino on September 8th, 1996, or September 6th, 1996, through September 8th. You see it in his name. We also know that Corey Edwards, one of the older OGs, one of the older guys in the Southside Compton Crips, was in Las Vegas as well. And that's proved independent of anything Duane Davis has said through this receipt. But the same time period, there he is. And we also know from Devontae Lee, that the older folks would tend to be with and Bobby Ladd, the older folks would tend to hang out with the older folks, the younger folks would tend to hang out with the younger folks, which tells you the inference you can draw is that the older folks are staying at the Monte Carlo. Then the video that you've seen a number of times. Orlando Anderson getting beat by Tupac Shakur, Suge Knight, Bun B, Neckbone, Trayvon Lane, Reggie Wright Jr. identified all those folks for you. And then you heard from security and from patrol that the person who was in the Dan Marino jersey was in fact Orlando Baby Lane Anderson. The other thing you heard was that when Orlando Anderson was asked, do you want to press charges, or do you want to assist, or do you want medical attention? Orlando says no. And what you learned from the witnesses is Orlando's beating required immediate violent retaliation. Bobby Ladd told you that he could not go back into the Compton and had suffered such a public beatdown. Mob James put it more succinctly when I asked him, hey, there's this rumor that Tupac knocked you out. And what did Mob James say? I would have shot him. Couldn't even get the sentence out of my mouth. Because that was the nature of the gang life in the 1990s in Compton. What Mob James said is, you had no choice. You had no choice. You could not go back to Compton having gotten beaten publicly. Otherwise, you were going to be tested by every person in your neighborhood. The need for retaliation exists without a single word from Duane Davis. Then 2.5 hours after the beating, Tupac and Suge leave for Club 662. And we heard from 3 people who were part of that entourage. We heard from Malcolm Greenidge, who was a performing artist, a member of the Outlaws, one of the groups that Tupac was associated with. We heard from Ingrid Stokes, and we heard from Leonard Jefferson. And they all joined at various points of the entourage. And here's an interesting question. So, were the women yelling for Tupac? So, Ingrid Stokes says, no, one of my girls in the back was talking to Suge. Malcolm says, yeah, there was some yelling, there was something going back and forth. They were talking to Tupac and Suge. And, ladies and gentlemen, there's no dispute that they were both there. It's just, depending on where you are, your perspective and how you're perceiving things changes. So, Ingrid Stokes is in the car with the women. Malcolm Greenidge is in the car behind them. They see how things are going differently. Doesn't mean they weren't there. And then Ms. Stokes does a favor of drawing this diagram of saying where she was. And what she says is that there's an empty lane to the left. There's Mr. Knight. Her car's behind Mr. Knight. And then she goes to the right of Mr. Knight. And then I took the opportunity to try and fill some of these gaps, poorly, but some of these gaps. And so what we hear about the lineup, and let's just focus for the time being on the lineup on the left with Suge's car. We heard from William Heimeyer, who had seen what's going on there.
And then with regards to the vehicles themselves, your testimony was that there was a white van of some sort, or maybe vehicle in front of the black BMW.
Yeah, it was a white Dodge Stratus.
I see. Is that a van? No, that's a car.
It's a two-door sedan.
Okay. And then behind it is the BMW.
Yes.
And then behind it are multiple cars leading back.
Yes.
And your testimony was that you had identified a Lex. Is it a Lexus behind it?
I think it was a Lexus. I believe so.
And then another vehicle, and then a white Chevy, and then it just kept going all the way down.
Correct.
So even though we're identifying these vehicles, you don't know how many vehicles were in the procession or the.
It was several. I didn't count them at the time, but it was a good 10 vehicles.
Okay.
Note about these clips. Ultimately, your memory is what determines what happened in this case, and be careful both of my clips and Mr. Sand's clips, like they're of what the context is of these statements. Don't just take my clips or Mr. Sam's clips word for it. Obviously, you've taken notes. You were here. So be careful and hold me to the fact that these clips accurately reflect what you remember in the case. But I think that's pretty long enough recitation to see what he's talking about, all the cars on the left. Now let's talk about the cars on the right. You have Ingrid in a Sebring, and she incidentally, you see after the shooting, the white Cadillac goes right on Cobalt, and then Ingrid also follows that Cadillac. Now, she's not following the Cadillac because she wants to go attack or pursue the shooting vehicle. She has her head down and she's freaking out, and she's like, let's get out of here. She makes the immediate right. She happens to follow the Cadillac. Now, this is an interesting thing that we talked about, perception. Because Duane Davis says, oh yeah, these broads, I think is what he's saying, these broads are trying to follow me, right? That's his perception. I mean, and to some extent it's understandable. They are following him, but they're not trying to pursue him. They're freaking out and trying to get out from around them. And then he says, and then we shot at them, and Ingrid says, it's possible that we were shot at. And then he says, we shot a windshield there. And then she says, no, that didn't happen. But a reasonable inference is, well, he thinks they're chasing them. They shoot at them, and then they stop. It's a reasonable inference to think that, hey, maybe they stopped because we hit them, right? It's all about, people have different perspectives based on what car they are in. Regarding the shooting, one arm out of the rear driver's side window, one firearm used, and we learned that it's a .40 caliber Glock semi-automatic from the cartridge cases recovered. And it's key, there's only one firearm used. We learned that Shug makes a U-turn once that happens and goes back to Las Vegas Boulevard and ultimately crashes, or the wheels on the other side of the car are destroyed from that turn when he gets up to Las Vegas Boulevard. And that he stops, he gets out of the car, he's bleeding from the head, and when police arrive, he says, help my friend, he's hurt. And a brief note about Mr. Knight. You also heard about Mr. Knight's level of cooperation, or lack thereof in this case, right? We learned that from Detective Becker that Mr. Knight did not initially want to come to talk to police, and then when he did, he came with 3 lawyers. And that when he came, he said, I didn't know anything, I didn't see anything. And then you also heard from Detective Dan Long, who said, I tried to reach out with him through a friend. I happened to have a friend who played football with him, or a coworker that played football with him. I tried to reach out to him then, and then when Mr. Knight heard what it was about, he immediately hung up. All right, so Mr. Knight does not want him to be involved in this case for a long time. And it said, at least to police, you heard from Brett Becker, that he didn't see anything. For whatever that's worth. We learned that Mr. Shakur is taken into an ambulance. He's able to talk. Malcolm Greenidge says, he tells me, get down. I don't want you to get hurt by the officers. I don't want you to get shot. So he's able to talk. He's still communicative. And so Gary Dale, who goes down with him to the hospital, says, hey, so who did this to you? What information can you get? And what Mr. Shakur says the whole time is, to the extent he's communicating, we'll take care of it. Which tells you 2 things, right? This is further part of the gang culture that's existing, right? This is the environment that's happening right here. It's not, let me tell you who did it, in the same way it wasn't for Orlando Anderson, let me tell you who did it. It was, we'll take care of it. The other thing, and friends, I think you can draw from this, though, is that we'll take care of it is, this is not a stranger. This is not a shock. This is not some random person, some random fan off the street. We'll take care of it. The inference there that you can draw reasonably using your common sense is, I know what this is about, and we will take care of it. While all this is going on, Reggie Wright Jr. and Mob James are at Club 662. And I think there was some inference that somehow Reggie Wright Jr. was involved in this, but we learned from James McDonald, when asked about it, impossible. What he said. That was the exact words. Impossible. And they're at Club 662. Reggie Wright was in charge of legitimate security. Mob James said he was in charge of mob security. Reggie says, well, I don't know if that's true. He may have been working on his own hustle. But Mob James says he was in charge of mob security. And then what we know is that from Reggie Wright Jr. that Alton Buntree McDonald and Roger Neckbone Williams arrived from the entourage, arrived from where the shooting occurred. Remember, Reggie said they told him about the shooting. He thought they were joking at first because sometimes they try and mess with him. They were also part of the group that had beaten Orlando Anderson that day. So where we are in the timeline is that two people who were part of the entourage come to Club 662 to tell Reggie and to tell Mob James what had happened. In fact, one of them is Mob James' own brother. Because they told Reggie about the shooting. And what did Reggie relay about the shooting? He immediately calls his father, the lieutenant of the gang, Southside, the lieutenant of the gang unit in Compton, and says, Southside did it. That night. This is not Mr. Davis saying Southside did it. This is that night contemporaneous. Southside did it. But Mob James goes one step further. He has more specific knowledge. And this is not surprising, really, right? Because he's talking to not the official security. He's talking to the mob folks, one of whom is his brother. And this is what he has to say about that.
When I was a part of that life, I was a part of that. And I was, no, because you asking something that's going to hurt this dude. And okay, let me stop.
Once again, I want
When we got back to Compton,
okay.
it was a gang war. People were getting hurt.
Okay.
People was being sought. People were looking for certain individuals from his neighborhood,
Okay.
as well they did mine.
Okay.
But Orlando, him, and certain other people were being assaulted because people wanted to kill them.
Sure. Were they the only ones that they wanted to kill?
Am I the only one up in here? No, they weren't the only one. Okay. It's his neighborhood in particular.
Right.
But they were the main subjects of a gang war. They was in the middle, such as me.
So you're telling us that people back home somehow had some type of information that said that that guy, as a bunch of other people, were involved in what?
In the murder of Tupac.
Okay. Well, my question to you.
Stop.
So, I gotta say, I've been doing this for a while. I have not seen testimony quite exactly go like that. But this is, and it's easy to get caught up in what was the drama of that moment and miss the content of the moment. I know I kind of missed some of it as well. I didn't ask any follow-up questions because I was just so caught up in the moment. But if you actually listen to what Mr. McDonald is saying, it's pretty damning regarding Mr. Davis. What does he say? That night, we know who did it. We're hunting for two people in particular, Orlando Anderson and that dude. That's what he says. And then Mr. Sam follows up, well, for what? For the murder of Tupac. Before we get to one word from Mr. Davis, we have contemporaneous 1996 intelligence. 1996 relay of who was responsible for the murder of Tupac Shakur. And he says two names and two names only. Orlando Anderson and Duane Keffe D. Davis. This guy. And he doesn't even want to be here, as you recall, right? He says, I don't want to be part of this. I don't want to put you in prison. And even tries to guide his Mr. Stamp away from asking these questions that lead to the inevitable conclusion that Mr. Davis is responsible for the murder of Tupac Shakur. And again, we haven't gotten to one word of what Mr. Davis has said. Not one word. We're not required to give you corroboration. But I don't know anything else to call that. Southside named that night Orlando Anderson, Keffe D. Before the world had the name, Mob Piru had that name. And a war breaks out in Compton. Right? Based on this. And it's not a war between two random gangs. Bobby Ladd told you there's over 50 gangs at the time. These two are the ones going back and forth. These two are the ones that are doing the killings. And what you heard is in a mere 10 days, 3 people were killed on mob and Piru side. You heard a 10-year-old girl got shot. She wasn't the only one. A lot of folks got shot, but Mob James told you is a lot of people got hurt behind this. And you could see that it was a very real thing to him. It's not just an abstraction. It's not just mob or Southside. These are real people whose lives were altered forever as a result of this ongoing war. So before Duane Davis says a single word, we know that Duane Davis is the leader and shot caller of the Southside Crips. Orlando Anderson was his nephew and the prince of the Southside Crips. That Zip Martin had a drug connection with Davis and connection with Sean Collins. That Southside, through Davis, was assisting Bad Boy Records with protection. That there was a fight at Lakewood Mall between Mob Piru and Southside Crips that involved a death row chain. That the Burr Street members, Corey Edwards and Orlando Anderson, were in Vegas for the Tyson fight. And one thing I want to add to this is, what Bobby Ladd told you is that Burr Street and Glencoe Street were fighting, right? There was an internal beef between them. And so this, I've heard the name Darnell Brim brought up. But which clique did Darnell Brim belong to? He belonged to Glencoe. So there's no way that he's hanging out with Orlando Anderson and Corey Edwards at the MGM. But before we get to a word of his, Tupac Shakur, members of the group beat up Orlando Anderson. 2.5 hours later, Tupac Shakur and the rest of the crew were headed to Club 662. The women in a Chrysler Sebring were communicating with Suge in Tupac's car. Now, it could just be one woman talking to Suge, or it could be a couple women talking to both Tupac and Suge, but we know there's some communication going on. That the white Cadillac pulls up and one arm out of the rear driver door shoots into Tupac's car. That the murder weapon is a .40 caliber Glock. That the women in the Sebring follow the white Cadillac. That the reports is 2662 from people at the scene, Reggie Wright Jr. said Southside did it, and that Mob James McDonald knew exactly who he was hunting for that night, Orlando Anderson and Duane Davis. So having said all that, now let's get to what Duane Davis said. Now you've heard over 8 hours, I'm not going to play that. I'm going to give you a few highlights. And again, just like with the clips of the testimony, it's up to you to determine what's actually real, what's actually not real. So if there's some question about what the clips were, please go back and look. Don't take my word for it. Verify everything, right? But we know that there's 4 statements in different settings with different motives. Right? We have a 2008 proffer for the feds. We have a 2009 interview with Dan Long and Darren Dupree. We have a 2017 Death Row Chronicles. And we have a 2019 book. And those 4 statements are not exactly the same. In fact, they're quite different depending on the context, right? I mean, that's just real. But the 4 statements are based on what Duane Davis's motivations are. The state's position has never been that Duane Davis just wants to unburden his soul to let everybody know about what happened. That he feels this guilt, that he just needs to let off his chest. That's never been the state's position. The state's position is Mr. Davis's actions are always driven by his self-interest. That doesn't mean it's not true. It just means that that's the lens for which you need to look at these statements. Right? So in 2008, the truth helps him. In 2009, the truth can hurt him. In 2017, the truth exposes him. And in 2019, the truth needs an excuse. Well, I'll explain that a little bit more as we go through each one of the statements. First, let's talk about 2008. The one-time truth is the incentive. In 2008, telling the truth helped Duane Davis, right? Because this is the exchange. You tell the truth, we drop your charges, right? That's the exchange that's going on here. And Mr. Sands had mentioned, well, nobody believed Mr. Davis, right? In his opening, well, nobody believed this, that's why it took so long to get here. Well, let me ask you this. Have you heard of Duane Davis doing a single day of that life sentence that was hanging over his head? He didn't do a single day on a life sentence hanging over his head. You think that's indicative about whether or not the federal agents, the federal government believed what Duane Davis was telling him was the truth? His incentive here, it's the purest incentive to tell the truth. So one thing that you need to evaluate, though, what the judge told you, is you need to determine whether a statement is voluntary or not voluntary. Right? That before you consider it, you got to make that determination. And a proffer is a voluntary statement, because if you look at the voluntary instructions, so it's what is juror instruction number 4. He talks about police coercion. But the one thing that's explicitly clear is police coercion does not include factors which motivate a person to speak because of self-interest or by the expectation of a benefit. Mr. Davis is in that room because he's trying to get out from under a life sentence. And what the law tells you is that is never police coercion. Additionally, a proffer is not coercion. A proffer agreement is something wherein both sides of the contract expect a benefit in exchange for entering the contract. The federal government expected a benefit, they wanted the information. Mr. Davis wanted a benefit, he wanted to not serve life in prison. And so when you're expecting a benefit, that you are not being coerced. That's a matter of law. So here, the law is clear, the benefit expected cannot make a statement involuntary. But the other thing that, again, is interesting is that at the same time, the benefit gave Duane Davis every reason to tell the truth. Every reason to tell the truth. So let's look at that 2000 statement. I want to play, again, a few clips.
Okay, where do you go to? What do you tell Zip right then?
What's that?
Do you tell Zip, hey, we're going to go handle this shit or whatever?
Yeah, they act like, do y'all want us to come? We like, we know where them motherfuckers at. They was telling us that they gonna be at the 662 club.
Who was saying that?
Everybody.
Everybody out there?
Yeah, everybody. They give us a concert.
Well, how do you know that Zip's got a gun? Does he tell you?
He told us in the lobby when I met him in the lobby. I got one.
Did you ask him? Do you have one, or he just tells you, hey, I got one?
Yeah, that's when they asked us, do we need some help? I got some Jimmy. We're like, yeah, okay, cool.
All right.
But only one he gave you.
Yeah.
From Zip Martin. And he talks about
And we went up to the 626 club. They didn't show up. We waited about 15, 20 minutes. They didn't show up. So it's like, let's go get some liquor. We stopped at the liquor store. I got out the van with their ass and jumped in the Cadillac.
And in other parts of the statement, he tells you who's in the Cadillac with him. And notably, the seating arrangement never changes. It's Terrence T. Brown or Bubble Up, the driver, Mr. Davis as the front passenger, DeAndre Big Dre or Freaky Dre Smith in the rear driver's side, and Orlando Baby Lane Anderson, Orlando Anderson.
Yeah. I think the little liquor store was right there. Then we came up Harmon, got the Las Vegas Boulevard. And shit, here they come in that BMW, a gang of cars, and brawls like, Tupac. And we like, there they go. Made a U-turn. We wasn't supposed to make a U. We just wanted a U-turn, and they was in the middle lane, and we just pulled up on the side and checked every car to see where they was.
So what directed your attention to him was some girl shouting at Tupac?
Tupac. He gave himself away. Otherwise, they would have got away. He all hanging out. You know how he do. Oh, they go bitch. And anyone got him.
You did a U-turn, so then you pull alongside of it. You guys were in the car. Have you already handed Lane the gun at this point, or at what point do you hand him the gun?
I thought he was going to pull on my side. You know, that's my little nephew. I'm going to look out for him, you know. And he pulled on their side.
So you were fitting to blast if you had to, or you were just...
Yeah, if we would have been on our side, I would have blasted.
Okay. So you hand the gun to the back seat.
Yeah.
You can hear Lane.
I gave it to Dre, and Dre was like, no. And Lane's like, yeah, he popped it too.
So a couple of things from that is, one, Mr. Davis says, I thought he was going to pull up on my side, which will be important later. And then two, that I was going to shoot, but then I gave the gun to the back. Dre gave the gun to him.
Lane starts blasting. You say Suge looks over, he sees you. He looks right at you.
Yeah, he looked at me.
Okay. Why are you looking right at me?
Fucking known each other since we were 7, 8 years old.
When he looks over at you, and then, Tupac's busy getting shot. Evidently, the story is Tupac's trying to either get out
In
of
the back seat or something.
Yeah, what do you see happening inside of their car?
I seen a bullet going Suge's head. I thought he was dead.
You see
He wasn't scraped, something in the head or something.
A piece of glass went into his neck right here.
And he had a thing in his head.
Yeah, a
too.
little gray.
Yeah, you got a gray from just
Yeah, I thought he was dead.
Okay. So, I'm sorry, did you guys stop the bowler stop the car and just let him get off?
Yeah. Then we made the right.
Okay, but he stopped for what you said. Why he boom, 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 got off, then he took off.
Then we made the right, and some bras in the sea breeze was following us. Stupid bitches. And we shot their window out, and they stopped.
So Tupac's trying to jump in the back seat. And what Suge doing? Just ducking?
Ducking. He couldn't really duck because he was too big. You know? Yeah.
So, and here is when Mr. Davis also mentions the girls in the Sebring. Hard to hear if he says Seabreeze or Sebring, but fundamentally the same thing. And then, he says, like, they're following us, and we're shooting at them, and then we hit the window, and they stop. And I think that's an inference he's drawing from them all of a sudden stopping because he thinks they're pursuing him. But we know from Ingrid they're not pursuing him. They're trying to get out of there. They just don't know how. So if we look at the 2008 proffer, one of the other interesting things if you listen to it is that he actually thinks he's on camera at the MGM. If you listen to him talking about the meeting at the restaurant or the cafe, he says, there's an exchange, like, y'all saw me there, right? Y'all saw me there? And then Darren Dupree says, oh man, I was there. He's like, oh, you're kidding. But he's like, he thinks he's on video. So this is why he's never denied being in Las Vegas. He actually thinks he's on video. In fact, he further asks, and you can check the transcript or check the audio yourself, like he further asks, did you guys have video at the ballet? So this is why he thinks he's not given up much, is because he thinks he's already on video. Now, they don't know, the shooting would never be captured on the video, but the idea that he was in Las Vegas, he's never disputed from 1998 to 2023, the whole part of this case is he's never disputed because he thought he was on video. Then he also adds the liquor bar. And what we heard from Mike Dorsey was there actually was a liquor store on Maryland Parkway. Right? That's what Mike Dorsey said. Mike Dorsey, the documentarian, he said, yeah, I looked that up. There actually was a liquor store on Maryland Parkway in that place. And then I think it was followed up by, at some point in the 90s, was Lee's Liquor going by Lee's Liquor Barn before there was a cease and desist order. He gives the white Cadillac in the seating position, the .40 caliber firearm. He shots from the rear driver. And this is really important because he provides a detail that is not publicly available. Right? The Sebring with the women following him. I'm not going to pretend that this case wasn't reported on in the previous years between 1996 and 2008. The caliber of firearm was in the papers. I bet you it's even in Mr. Davis's comments. The fact that a white Cadillac was involved, absolutely well known. What was not well known, what was never publicized by 2008, was the Sebring with the women following him. So where does he get that detail? And what's fascinating about it again is Ingrid's not following him. It just looks like that from the perspective of somebody in the white Cadillac. The open lane. So Mr. Davis says, I thought he was going to pull up on my side so I could do the shooting. And, as frequently as I've heard this tape, that part never made any sense to me. And trust me, folks, I've listened to this once or twice. And then I saw Miss Stokes' drawing. Right? What does she tell you? She tells you that this lane is open. Right? In my mind's eye, when I'm thinking, well, why would you ever think that the car, if you're all the way to the edge, the car would be pulling up on your side, the passenger side? But Ms. Stokes says that, and then Mr. Heidmeyer, who's at the Max Motel, remember he's the one looking down on this, he also says that after, what he sees is Suge being able to turn immediately, make a U-turn immediately, and go back down Flamingo, also indicating that there's nobody in that lane, because Suge is not in the left turn lane, right? He's trying to go straight. Then there's nobody in the left turn lane, which is why Mr. Davis could say, I thought they were going to pull up so I could do the shooting. Because if this lane was full, that makes no sense. But since we know that that lane is empty, Mr. Davis's story makes sense. And the other thing about the 2008 proffer is where Mr. Davis pushes back. He's not just saying yes, yes, yes. He suggested Lane in the van too. He corrected. No, he's in the Cadillac. They suggested Orlando's behind the driver. There's confusion about where everybody sat. And Mr. Davis says, no, Orlando is behind me. And then there's this whole exchange about what they did with the gun. And Mr. Davis said, we left the gun on the tire of the Cadillac. And the officers just don't believe it. Like, that makes no sense at all. You've got this gun used in a murder. Why would you put that on a tire? That doesn't make any sense at all. And Mr. Davis's attorney, Wayne Higgins, says, I mean, you guys aren't thinking like folks from Compton. You guys are thinking like cops. And then what Mr. Davis says is, you want the truth or you want me to lie? Because the truth is, that's where the gun was. So it's not as though Mr. Davis would not push back when given something that wasn't true. Lastly, Mr. Davis's statement makes no sense as a lie. The 2008 statement makes no sense as a lie. He could have said he was just a witness. Right? Isn't there, he has his attorney with him, and he kind of does this in 2009. He could have just said, man, Lando had the gun, I was just in the car along for the ride, I had no idea that this was going to go down. Or, man, like, you want the information about what would happen with the Tupac case? I can give that to you. Lando told, I was the shot caller, right? Lando told me, my nephew told me, Big Dre told me, Terrence Bubble Up Brown told me. They all told me what happened. I can give you all the information you need. He never has to put himself in the car. It doesn't make sense as a lie. And mind you, this is for the notorious B.I.G. investigation. This isn't even the Tupac investigation. So if the notion is Mr. Davis is creating this whole story, why would he create the story that makes him legally liable for murder when he could just make himself a witness? He has non-public information about the woman. He has unnecessary details. And those unnecessary details are like Zip. Why are we including Zip? Right? If anything, for somebody who's trying to get away with a lie, it makes it worse. Because that's something that if Zip were to ever have cooperated, he didn't. But if Zip were ever to cooperate, that's something they could say, no, you're lying, your deal's off. Why add Club 662? Why even add that detail? Why can't it just be, we were driving down the street, I happened to be in the car, and then we started blasting? Why add that little granular detail? Because there were other people at Club 662 that could have said, no, he's never there. Why add the liquor store on Maryland Parkway? And the changing of the cars? If anything, all you're doing is implicating more people. He says, well, I start off in the van with Corey and these other guys, and then they were whining too much, so at the liquor store, I go and switch cars. Why are you adding this unnecessary lie if it's a lie? Why isn't it just, man, I heard this is what happened, I saw this is what happened, all these unnecessary details? Why add Dre passing up the shot? What does that contribute if this is a lie? And the other thing I'll be upfront with you is that not everything that Mr. Davis recalls 12 years later it can be confirmed, and some of it's probably wrong, right? Like, he says that Mr. Shakur, he saw Mr. Shakur the night before, showed him Mr. Shakur the night before, Malcolm Greenidge and Reggie Wright Jr. said they came in Saturday. These are differences that 12 years later will cause are reasonable things that you may not remember. It's not whether or not he gets every detail right 12 years later. What he's focused on is the material things, which are what happened in that car for the shooting of Tupac Shakur. And if you look at this, the 2008 federal proffer, he admits to being the Southside leader, front passenger seat, gets the gun from Zip, gives the gun to the back of the Cadillac, shot from the rear. And this is when he has the most incentive to tell the truth. So let's talk about 2009. Now 2009 is just weird. Like, this conversation is just a weird one, right? Because Dan Long is coming in thinking, I'm going to interview somebody and maybe I'll get information enough to arrest somebody. Wayne Higgins is telling Mr. Davis, hey, be careful what you say, you might get arrested. And what's going on there, what came out during Detective Long's, I think it's cross-examination by Mr. DiGiacomo, is that Duane Davis was trying to work off charges. Again, he's expecting a benefit. So the one thing we know is that it's voluntary because if he's expecting a benefit, it's voluntary. And in fact, he even has his attorney there. He's not hooked up. He's with his attorney there voluntarily to give this interview. But it is weird. And Davis's attorney tells him to distance himself from the gun. Right? So he says, well, this is what he says.
Just like that. Just like that.
Somewhere closer to that.
Yeah. Can I talk to D for 1 second?
Sure, go ahead.
I'm talking about without you.
Oh, yeah, absolutely.
Absolutely. I'll step out.
Yeah, wait too. Just so you can clarify it. What's up, man? Okay. Oh, one thing, let me just real quick. Look, you're doing a pretty good job. I know it's kind of hard, but, you know, you ain't supposed to be getting in anything like you was involved in murder. You gotta keep it really clean.
But you told what you told us. Stay consistent. What you told us.
He gave me the gun. He gave me the gun.
So what happens here is Dan Long has left the room. Mr. Davis says, "Hey, can I talk to D?" And Darren's like, "Yeah." Dan Long says, "Yeah, sure." But no, with you out of the room. So now you have Detective Darren Dupree. You have Wayne Higgins, Mr. Davis' attorney, and Mr. Davis. And what Wayne Higgins tells Mr. Davis is, "Hey, look, you're not supposed to be talking yourself into a murder right now, so be careful." Later in the conversation, he says, "This man is here trying to put a case on you." Right? That's what he's trying to do. And what Darren Dupree is there, Darren was also part of the federal task force. And what Darren Dupree is talking about, you got to keep it consistent. And why? Because if he tells a vastly different story here, then the federal proffer goes away. Because then the federal government's like, well, were you lying then or are you lying now? How can we be assured that you've met your part of the bargain if you're telling a totally different story in these two different instances? So what Duane Davis is trying to do is thread a needle. He's trying to keep it consistent enough in order to keep his proffer deal where his only incentive was to tell the truth. But not catch a case from Dan Long, not trying to catch a murder case from Dan Long. And what is absolutely fascinating is, so when Wayne Higgins is telling him, hey look, you want to distance yourself from the gun, Mr. Davis pushes back his own attorney. He gave me the gun. He gave me the gun. Am I not supposed to say that? He gave me the gun. So even in his unguarded moments with a detective and an attorney, he's saying, Sid Martin gave me the gun. Because the first part of the story says, Orlando got the gun, and then after this interlude, he said, nah, it was me. Like, he gave me the gun. Now, he listens to Wayne Higgins' advice a little bit, and he alters the sequence of events a little bit. He says, I gave Dre the gun before we went hunting, but they were still on their way hunting for Mr. Shakur. And if you look at this statement, he still is the leader of Southside. He's still in the front passenger seat. He still gets the gun from Zip. He still gives the gun to the back of the Cadillac. The sequencing is a little different, and the shots are still from the rear. He still puts himself in the Cadillac as the shot caller. Now, 2017 is a completely different scenario. Now the gun is dangerous to admit. And if you recall that some of the conversations that happened, this is the one to the BET Chronicles where we've got like some audio and you hear Mike Dorsey's phone clicking a little bit and you hear these pieces of conversation where Mario Diaz is trying to get this information for his TV show. Here, Mr. Davis clearly has liability. It even says they could give me the death penalty for this. So he's very aware of what he can and cannot say, or at least he's trying to not get in trouble. But he still provides motive because of Orlando's beating. He still provides the same people in the Cadillac. He still goes to 662 to seek a violent confrontation. I think this time it's let's just get into a fight as opposed to a shooting, but it's still a violent confrontation he's seeking. He still sees them on Flamingo. They make a U-turn. They turn to confront Tupac and Suge. What it's just only thing that's different here is that the shots came from the back. I don't know what happened. I think they were blasted. We were blasted. I have no idea. So the 2017 statement is Southside leader, front passenger seat, gun from Zip, he denies, gives the gun to the back of the Cadillac, kind of hedges about where the gun came from, and then still shots come from the rear.
Mr. Perez? I've received notification that one of our jurors does need to use the restroom at this time, so we are going to take a break. During this recess, you are admonished not to talk or converse amongst yourselves with anyone else on any subject connected to the trial, or read, watch, listen to any report or commentary on the trial of any person connected to this case by any medium of information, including without limitation, newspaper, television, internet, radio, or form or express any opinion on any subject connected with the trial until the case is submitted to you. Please rise for our jury. I'll have you guys back here at 10:40. For the record, the jury has exited the room. Is there anything we need to address outside the presence?
Talking to Steve.
Okay. I anticipate we'll roll straight through at this point, so if anybody needs to use the restroom, counsel or anyone, or Mr. Davis, please do that at this time.
I only have 3 hours left, Your Honor, so I think we should be fine.
Hilarious. Love it. back on record in C-377407. Anything you need to address before bringing in the jury?
Not a mistake.
Anything we need to address?
No.
Okay, let's bring in the jury.
Stand for
Address.
jury.
Party stipulate to the presence of the jury.
Yes, Your Honor.
You may be seated. Mr. Peral, you may resume with your closing arguments. Thank you.
Thank you. So where we were is in 2017, he had the incentive to protect what he was saying because he had more exposure. And so he's still a Southside leader, he's still the front passenger seat, he denies the gun from Zip, he hedges, it's not very clear, but then he says the shots coming from the rear. So now let's look at 2019, good luck. But first, when we're looking at the 2017, this isn't confusion. It's not as though Mr. Davis is like, well, I don't know how to keep this story straight about what happened in the Cadillac in Las Vegas. It's calculation, right? It's his self-interest. And his self-interest dictates what he says, but it's never, I'm not sure what happened in the Cadillac while I was in Las Vegas. Okay, 2019. Now the story pays him, and an excuse protects him. And so, one thing I just want to talk about briefly about what an adopted admission is, and that's number 39. A statement doesn't have to be made by a defendant in order to be considered his own statement. If you find, and again, this is your province, if you find that a defendant by his own words or conduct manifested that he adopted a statement or believed it to be true, you may consider that statement as the defendant's own statement, the same as if he made it himself. And so, we have the book. It's Keffe D with Yusuf Jah. Now, I don't know the correct way to spell Keffe D. Maybe with 2 F's, maybe with 2 E's, maybe with 3 E's. I've tried to look it up. There's no place for an official spelling of Keffe. But this is what he tells you about it.
Cool. Yeah, this is my book here. I would like you guys to buy it and get the real truth instead of from a cop or some fucking industry people, some bullshit. You getting it from the real motherfucker. So go get the book, and you can get the real truth about this whole situation. Thank you.
So that is a textbook version of an adopted admission, right? What he's saying is, this is my book. This is the truth. Please go get it. So if Yusuf Jah wrote it, it doesn't matter. If Keffe D wrote it, it doesn't matter. If some homeless dude on the street wrote it, it doesn't matter. The second he holds it up and says, this is the truth, this is the true version, come and get it, it is now an adopted admission as though he said it from himself. And these are some of the things he says. I had risen in the ranks to become a major shot caller for the notorious Southside Compton Crips. And we actually know this outside, right? We've learned this before. When he talks about the Glock, I pulled out the Glock that Zip had given me and tossed it in the back seat. So that's doing 2 things. One is telling you that Zip gave him the Glock and he tossed it in the back seat. Bubble Up did the driving. Baby Lane and Freaky were riding in the back. It's the same composition of people in the Cadillac. Bubble Up busted a U-turn, hit the gutter lane on their asses. They had a caravan of at least 18 to 20 luxury cars. As they sat in traffic in the middle lane, we slowly rolled past each one, looking until each car until we pulled up to the front vehicle and found who we were looking for. And this is key, right? Because in every iteration, this is an intended target, right? It was initially they were looking for them at 662. They gave up the search. But once they see them again, they reinitiate the mission. They make the U-turn. And they're going there for a very specific purpose, to shoot and kill the people in the BMW. Now this is the part that Mr. Davis adds, right? The shit was on. Tupac made an erratic move and began to reach down beneath his seat. It was the first and only time in my life that I could relate to the police command, keep your hands where I can see them. Instead, Pac pulled out a strap, and that's when the fireworks started. One of my guys from the backseat grabbed the Glock and started busting. So now Mr. Davis, because he has some exposure, is trying to create a self-defense narrative. But have you heard of any other firearm being used? No. Or have you seen any physical evidence of a firearm being used? No. Is there any suggestion that another firearm is being used? No. So what do we do with this? We don't throw away everything Mr. Davis is saying. What we say is, what is his self-interest in saying this? He published a book, and he doesn't want to get arrested for the admissions in the book. Even though, as we'll learn very soon, that this doesn't even qualify as legal evidence. Finally, a theme that was reiterated throughout all of Mr. Davis' statements is them jumping on my nephew gave us the ultimate green light to do something to their ass. And I know you folks have heard a lot of Mr. Davis over the last couple of weeks. One interesting thing that you hear recurring is whenever Mr. Davis is asked, do you feel bad for what happened? Do you feel bad for having participated in the murder of Mr. Shakur? And Mr. Davis has two responses. One, Tupac brought it on himself, which in this courtroom, not true. In the world of gangs, it's a different story. The other thing Mr. Davis always says is, I'm sad what it did to my life. If you listen to any one of those instances, it's not about his actions. He feels justified in the world that he lives in, to take these actions. He's more upset about the consequences of having participated in the murder of Tupac Shakur. And on the book, he says he's the leader. He was in the car. He armed the shooter. He hunted the victim. He did it for revenge. He published the proffer, which is interesting. Because in what he says in the book is, I went there, I did a proffer. I had to do it, I had to tell the truth, that's what my attorney told me. And so, at that point, Mr. Davis has broken the confidentiality of the proffer. Now, he's not the first one. Greg Kading, in his personal capacity, published the details of the proffer. There's no doubt about that. In his personal capacity after leaving the LAPD. And no charges followed as a result of that, even though that's proffer. Then, in 2019, Mr. Davis does two things. He publishes the fact of the proffer and starts profiting off the proffer as well. And, there's a fair critique of Greg Kading to say, hey, you are making money off your investigation. That's a fair critique. But it is an entirely different proposition to be profiting from a murder. And that is what Mr. Davis is doing. He is profiting off a murder at this point. And in the book, Mr. Sams had pointed it out that in the book, he does say that some of the facts have been changed. There is a disclaimer here. Some of the facts have been changed. And they have. Some of the facts have been changed. But, many years ago, O.J. Simpson wrote a book that said, If I Did It. Duane Davis wrote the book, I Did It. And so in 2019, he's still the Southside leader. He's still in the front passenger seat. He gets the gun from Zip. The gun moves towards the rear. There's shots from the rear. And the point of this is not to say all these other facts align. In fact, he does change things in the book. He says, he calls Lil Owl the Reaper. He changes names. He changes hotels. Instead of the Monte Carlo, now he's at the Caesar's Palace. He changes some of these things around. He's a little self-aggrandizing, not shockingly. But the core facts remain. The material facts remain. The statements are different. But again, his motivation is what changes those statements. In 2008, the truth helps him. 2009, the truth can hurt him. 2017, the truth exposes him. 2019, the truth needs an excuse. Because when he's going public saying, I participated in the killing, I orchestrated the killing of Tupac Shakur. He needs at least for some public and legal reasons to say, hey, he started blasting first, even though we know that's a lie. And so these are the changes, whether he procures a firearm from Zip, admitting he fired it from the, saying who fired from the back of the Cadillac, and adding them Tupac Shakur's back. These things are about one thing, though, his own responsibility. But let's talk about the thing that never changes. He never gets himself out of the Cadillac. In 2008, 2009, 2017, 2019. And the one thing he never says from 1998 to 2023 is, I wasn't there. Mr. Sam proposed to you this idea that this case was about fact versus fiction. I disagree. This case, like all cases, is about evidence versus argument. The judge told you what each is. Evidence, which you are to consider in this case, consists of the testimony of the witnesses, the exhibits, and any facts agreed to by counsel. That is what evidence is. Mr. Samt told you that, well, you know, microphone is always a microphone, and that's the only way you can know something is true if it's an object that retains its property over years. That's no basis in the law. And the other part is, statements, arguments, and opinions of counsel are not evidence in this case. You guys have done a great job listening to me for probably too long. But what I say, what Mr. Sam says, what Mr. DiGiacomo says, is not evidence. Our little clips, even the little clips I provided you of the testimonies, it's your understanding of what you've heard and the accumulation of things that have been admitted, including those statements. That's the evidence in this case. And so when Mr. Sanford tells you that everything that Mr. Davis said was BS, that's not evidence. That's argument. Because I'm sure defense will argue Duane Davis is making this all up. But according to who? According to who? Detective Dan Long said he was ready to arrest. Mob James told you he knew precisely who he was hunting. According to who is this a lie? Who have you heard from say that this is a lie? What is the evidence in this case? In fact, Darren Dupree, a man who worked 33 years in homicide, who was part of that federal task force, said this.
I didn't think Mr. Davis was lying because he put the gun in his nephew's hand. And if anybody knows anything from what I hear, Mr. Orlando Anderson was the man besides Keffe D in that neighborhood. He was the prince, and his family loved him. I didn't think that Mr. Davis would put the gun in his own nephew's hand, dead or alive, and put that smut on him unless it was true. The person that killed Tupac.
And again, your memory governs, not a little clip that I put together. I think it's a pretty thorough explanation of why Mr. Dupree doesn't think Mr. Davis is a liar. Because think about what this story is if Mr. Davis made it up. What kind of person would say that the person I love, the person who was beat down, is responsible for one of the most notorious murders in Las Vegas, in the country? He would not. It would make no sense to put that smut, as Detective Dupree, on somebody that you love as a lie. Now, as a truth to get out of a life sentence, that's a different story. Okay, I'm going to briefly discuss murder, and then I promise I'll sit down. Who fired is not the question, right? So when we're talking about the legal issues in the case, who fired is not the question. It's not the question you ask. The law asks two questions instead. Did Mr. Davis help the killing with intent? He has to have the intent. Or did he agree to it? And you take that one at a time. So we're not required to prove precisely which defendant actually committed the crime and which defendant aided and abetted. In fact, you don't even have to agree whether it's aiding, abetting, or directly. And the other thing is, and this is important in this case because you've heard a lot of other people's names, you're not here to decide other people's guilt, whether they're guilty or not guilty. Mr. Davis can be guilty, and somebody else can also be guilty. You're not here to decide anything beyond Mr. Davis's guilt or being not guilty. So what's aiding and abetting? It's in instruction number 9, all persons who knowingly and with criminal intent, and he has to have the intent to be clear, the criminal intent to aid and abet are principles and are equally guilty. To aid and abet is to act with the intention that the crime be committed. You don't have to pull the trigger. If you knowingly help the crime along, meaning for it to happen, the law treats you as though you pulled the trigger yourself. And so what do we have here? We have Mr. Davis getting the gun. Mr. Davis's status as the shot caller, right? His status is what makes him part of this. He aided and abetted this murder. He got the Glock that Zip had given him and tossed it in the bag. And he got the gun for what? For what purpose? Why does he have this gun? Why does he give it back? You know the answer. And there's a second independent path. So you have aiding and abetting, which is I helped the crime. And then there's conspiracy. I agreed to the crime. And I agreed to the crime, and one of the ways you prove that up is normally you don't have a handshake or a contract saying, we're going to go murder somebody today. Normally you do it by the coordinated series of events, who you're with before, during, and after the crime occurs. And in that instance, the act of one becomes the act of all. So what makes a conspiracy here? We talked about this. It's a coordinated series of acts. The act of one is the act of all. And so whether or not Mr. Davis fired, and he did, right? That's not our theory. The shot from his crew while he was leading them with the gun he provided in furtherance of the plan, in the eyes of the law, he's guilty of the murder. And one of the most difficult things for Mr. Davis in this case is his status and his presence. You combine those two. So what is his status? He's the shot caller, right? In every instance, in every iteration, he's the leader of the Southside Crips. Now sometimes he says, I used to be the leader. But in every iteration, he's the leader of the Southside Crips. And we've established that with Mr. Davis' statements and without Mr. Davis' statements, right? We've established that through all the witnesses who discussed Mr. Davis in this case agreed. Mr. Davis was the leader, Mr. Davis was a shot caller. So he has that status, and then we have his presence. In every iteration, he's inside the car. So, when you have the shot caller sitting shotgun, as shots are fired, there can be no doubt that Mr. Davis is liable for that murder, is responsible for that murder, and frankly coordinating that murder. The shot caller doesn't just ride along. That's what you heard Bobby Ladd say. In no world does a shot caller just sit there. This shooting, if he's in the car, now, if he's not there, all bets are off. But if he's in the car, he is responsible. He's the one guiding. He's the one giving the approval. In his own words, he's the one giving the ultimate green light. Now, with murder the laws of murder here are that you have to have malice. And malice here is no mystery. If you're acting in revenge, that's malice. It's malice enough to establish a murder. Why is Mr. Davis on the hunt for Mr. Shakur or Mr. Knight? Revenge. There's no question about that. And then the real question for you folks is going to be the level of degree, first or second degree. And that is a meaningful distinction, first degree versus second degree murder. That's one thing that you have to really look at. So the degree turns on Davis's own mind. Like what can we establish that he's thinking? And you never know what somebody is thinking. You can never pop in their brain. You can only learn by their actions and what they're doing. So willfulness is the intent to kill. He armed himself for one reason. He first got the gun for himself and then gave it back for one reason, and that is the intent to kill. Deliberate. He got the gun. He organized the group. He hunted for Mr. Shakur. This is a course of action chosen and weighed. It's not a reflex. This happened 2.5 hours later. Right? It's not as though I hear this, let me grab my gun, and let me start shooting. 2.5 hours later, he has to organize the group. The van and the Cadillac. This is a deliberate set of actions. And then finally, premeditated. Premeditation is design and determination to kill distinctly formed in the mind at the time of the killing. He armed himself before he ever laid eyes on Tupac that night. The design was formed long before the shot. And so, here's an interesting break. We have him going to Club 662 for the express purpose of a violent confrontation. And then he goes to the liquor bar. And it's over, right? It's over. And then they're driving along, and they see Mr. Shakur. And again, they could have just driven off. But instead, they make the U-turn. And it's that U-turn is the premeditation. It need not be a day, minute. It can be as quick as successive thoughts of the mind. And in that minute, in that second, when they decide to make the U-turn, with the shock collar sitting shotgun, the decision had been made. It's a plan, not an impulse. We know the beating, he arms himself, he organizes the hunt into the U-turn. The firearm as a deadly weapon. And so this has been something that I've heard in Mr. Sam's opening. Well, where's the gun? Well, the law says we don't need to require the gun. And of course that makes sense. Frequently, if you commit a crime, you commit a murder with a gun, you're not keeping it with you. And so the law doesn't require us to have a gun. Nor does it require us to have a Cadillac, by the way. And what would those things tell you anyway? It would tell you that a gun was used in this crime. Okay, we know that. We would know that Cadillac was used in this crime. Okay, we know that. And what's interesting about the Glock is that we heard from the Nibin investigator, that Glock has never been used again. In the 30 years, the Glock has never been used again. It was disposed of. And he is guilty of use with a deadly weapon, even if he's not the person that pulls the trigger, as long as he armed the shooter and wants him to use it as part of the continuation of the crime. So you don't have to be the person pulling the trigger. If it's part of your conspiracy to use the gun, you're guilty of that with use of a deadly weapon. And finally, I want to just give this the short shrift that it deserves. Mr. Davis, in his book and in the 2017 documentary, tries to make some claim that, well, Tupac started blasting at us in some effort to make a self-defense claim. But self-defense is never available to the original aggressor, a person who sought the quarrel with the design to force a deadly issue. The person killing must act under the influence of those fears alone and not in revenge. Who's doing the hunting? Even if we were to buy the public story as opposed to the private story, even if we were to buy the public story, it's still not self-defense. It's still not self-defense. So, it's not a crime, it's not first-degree murder, it's not second-degree murder without use of a deadly weapon, because we know that a deadly weapon was used. It's not guilty because it's not self-defense. Because you can establish the crime, a large part of the crime, the context of the crime, and with Bob James, frankly, the crime, without Mr. Davis' statement. And then when you throw in Mr. Davis' statements, it's not guilty. And because it was premeditated, willful, and deliberate, it's not second-degree murder either. It's first-degree murder. Now, the last thing I'll talk to you about is Mr. Davis's view about the compensation he has gotten. And he's gotten compensation. He got compensation for the 2017 documentary. He got compensation for the book. He's gotten compensation for the YouTube videos. He's gotten compensation for a lot of these things. Right? And there's the argument that, well, how do we know he did it if he's getting paid for it? Well, those aren't mutually exclusive. And Mr. Davis explains explicitly what the nature of his money is. In fact, this is after he's arrested for the murder, not before. After, even after being arrested for the murder. This is what he says.
I think I got blood on my money.
Blood on my money, and then laughing about it. And whose blood is on that money? Mr. Shakur's. For nearly 18 years, Duane Davis has told the police, television, books, YouTube interviewers, anybody that will listen, he has told, He is responsible for the murder of Tupac Shakur. Tell him you hear him. Find him guilty.
Thank you, Mr. Palal. Mr. Sanft, are you prepared to give your closing argument?
You go first, man.
You may. At this time, we're going to take a 10-minute recess. During this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected to the trial, or read, watch, or listen to any report or commentary on the trial of any person connected with this case by any medium of information, including without limitation, newspaper, television, internet, and radio, or form or express any opinion on any subject connected with the trial until the case is submitted to you. Please rise for the jury. For the record, the jury has exited the room. My understanding is Mr. Davis isn't feeling great. Am I able to give him cough drops, Mr. CCDC?
I was told he couldn't, otherwise I would have been doing that, Your Honor, just to let you know.
CCDC, who's in charge here?
I don't have a problem.
You don't have a problem with it? Okay. These are from my staff, so I obviously use them as
As long as it's not the attorney. Oh.
No, it's fine. Don't worry about it. All right, we'll be in recess.
Thank you, Honor. I appreciate that.
No problem. Let's go back on record. We're back on record in C-377-407. Mr. Davis is back after being checked out by medical staff. Anything we need to address outside the presence?
No, Your Honor.
Thank you. You're welcome. Mr. Giacomo, let me know. Okay. All right, let's bring in the jury. Everyone rise. All right, so the party stipulates to the presence of the jury.
Yes, sure. Sure.
You may be seated. Welcome back, ladies and gentlemen. We are now into the defense closing argument. Mr. Sanf, whenever you're ready, you may proceed.
Thank you, Your Honor. Good morning, everyone. One of the things that obviously that we've learned over the time that we've spent here together is that it's your recollection that governs whether or not whatever the evidence is. So even though we're sitting here and we're telling you what we think the evidence has shown, when you go back into that room and there's both of you, your notes and your recollections will govern what the facts are in the case. Right? So what I'm going to try to do is show you things that I believe are relevant in the course of the trial. Now, one of the things you just have to understand is that Mr. Perdue has, I think, brought this up as well, is that with regards to the snippets, right, you know, the videos and so forth that I'll show you, I don't want you just to take it as, you know, gospel truth. Whatever those snippets are, compare that against your notes and your recollection. Is that fair? Okay. Now, in addition to that, we have to ask ourselves the question, really, at this particular point. It's like, why are we here 30 years later if Duane Davis had actually confessed, truly confessed? That's really the question of the day, right? You know, when you sit around and you think about a case like this over 30 years, you have to ask yourself, like, what did he really confess to that was true? So let's walk through what we know and then figure out at the end where they are in terms of their case. Now, I have to give you this caveat, though. Something called burden shifting. Meaning, remember in the beginning I said, you know, if I just sat there and played with my hair, looked out the window, technically, and really honestly, the state of Nevada still has to show you proof beyond a reasonable doubt, right? I could just not say anything at all and just sit there. And the worry is, when I put on a presentation like this, is that you're going to listen to my presentation, listen to the state's presentation, and go, well, you know, I wasn't quite sure about the state, but I definitely don't believe in the defense statements, and so as a result, lean back towards the other side. If I were to sit down right now, you would still be obligated to weigh all the evidence in terms of what the state's burden or job is in this case. Their responsibility is to show you that they've proven their case beyond reasonable doubt. Right? Now, one of the things I've asked everyone at some point, I think, was what favorite movie you have. My favorite movie, I just took this picture this morning, early morning, working on this PowerPoint, is Ocean's 11. And the reason why I like Ocean's 11 because it's like a twisty movie at the end, right? You sort of have to wait till the end to realize some of the twists and turns. And some of the questions that were asked during the course of this trial, you may be thinking in your mind, like, why ask that question? Or why bring in this piece of evidence into the case? And so what you're going to learn during the course of this thing is that the evidence that we have is incomplete in this case, right? You hear from both Detective Becker and Detective Long that they are missing officer reports. Now, why is that important? It's because we're not giving you everything. And you as jurors deserve everything in terms of the full weight of the evidence in this case. We don't have it. And because of that, you have to keep in mind as we're going through all the evidence in this case that, look, the Metro's investigation was compromised. Weird that you would have a detective concerned enough about his file that he would lock it up. Weird enough that you would have another detective basically have to create a false case number to hide people from unauthorized access of a file until you realize who it's about. Tupac Shakur was the most famous rapper in the world. And everyone wanted to know the answer to the question, who shot and killed him? Now, one of the things that we've talked about before is Compton PD, and you've learned this already, right? We told you in the beginning, look, Compton PD was shut down due to corruption. And who did we hear this from? We heard it from Special Agent Lee. If I can turn this up. Oh. You know, we had it working before, so I don't know why it's not working now.
Okay.
This tech guy.
This is the tech guy.
No, it is not.
Doesn't get paid enough. He does
He
not.
just happens to know this one button.
And it's in terms of the Compton Police Department. Fair to say that it, so Special Agent Lee talks a little bit about the Compton. And it's in terms of the Compton Police Department. Fair to say that at some point they actually disbanded or they were shut down.
Yes, that's accurate.
And that would have been at what year?
I don't remember specifically. It was somewhere in the late 90s, I believe, or early 2000 period.
Okay. And why did they get disbanded?
I don't know these specifics. I know there was numerous allegations of corruption and such and things like that in the department, organizational, structural deficiencies.
All right, so once again, we learned this information. Now, one of the things that I'm going to turn your attention to in your instructions, so you can just write down this particular instruction, is instruction number 42. This instruction number 42 is an instruction that says the following, and I want to make sure everyone understands this. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given any admission or confession. Now, what does that mean? That means if you believed his own statements, as Mr. Davis has, been telegraphed or whatever we presented for Mr. Davis in this case, that you don't have to corroborate any of it. But here's the thing. If you don't believe it, then I think you do have to corroborate. So even though the state may say, well, hey, we don't have to corroborate anything, but we're going to show you guys stuff. In reality, corroboration is important. We need to know and test the veracity of something. So if you don't believe his statements, then we do have to corroborate. And in this particular case, number 44 deals specifically with the credibility of a witness. And I just want to read this real quick for you guys, because when we go through it, this will be important. The credibility or believability of a witness should be determined by his manner on the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. That's the stuff, right? When you hear the testimony of people up on the stand, when you hear them talk about what they recall, that's the kind of thing you want to do with regards to that credibility. And when you do determine if you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. So the idea behind it is corroborate, right? I say something, should be proved by something else. Now, you're also asked in this case, just don't leave your common sense at the door. I mean, look, when you walk in here, it's not suspended disbelief and you're not watching a movie. Your common sense and life experience as men and women of our community governs. in terms of how you look at the case and what you think about the facts in the case. Now, one of the things that the state has talked about was this idea of direct and circumstantial information. Now, here's the thing. I think Mr. Halal had said something along the lines of, this case is drenched in circumstantial evidence. He talked about this idea of rain, right? So, okay, yeah, you see outside, we're in Vegas, dark clouds over the horizon, humidity goes up, it's, you can feel it, you can smell the rain in the air, the ground is wet. And the car's wet, right? Those are all things that could indicate to you when you leave here that it rained. Sure, right? You can agree to that. Now here's the thing about it. Each of those details are facts. So when we say you smelt the air, that's a fact. You experienced that yourself. That's direct evidence of an element to the circumstantial evidence. When you say you see puddles on the ground, that's direct evidence, right? So it's not like it's circumstantial. You still have to show facts in order for you to get to that circumstantial decision or result. Does that make sense, everybody? Okay. So in this case, when we talk about fact versus fiction, what we're talking about in this particular case goes to the heart of the issue with dirty cops. And this is coercion 101. Now, in this case, what you've learned and what hopefully you've heard during the time we spent together is that Mr. Davis wanted his own attorney. He default. And Greg Cady, this disgraced LAPD detective, calls him dirty. And Mr. P, or Detective Dupree in this case, was in the room. Now, even though he told you that he was not in the room, he's in the room when they're having conversations. And this is what happens in this case.
There's some problems, in my opinion. This may not be a shared opinion, but I just don't believe in Edie's ethics. I think he's a dirty attorney. I think that he will lie, cheat, and steal in order to get himself out of any kind of problem. I think that there's ethical problems with the way that he had Orlando testify on behalf of Suge Knight, and that whole thing is the problem we don't want to have to deal with. And as you know, Edie Fall also represents Michael Thoreau, and we just don't want all those problems.
He represents Michael Thoreau right now?
Well, yeah, right now.
What you just heard right there is a detective telling a defendant who his choice of attorney is and not. How does that reconcile in everyone's brain? How does that become something that's okay? The reason why that's important is because of the jury instructions, specifically on the issue of, whether or not someone's coerced into a discussion about anything to do with anything. And just for those who are following along here and keeping score, this would be jury instruction number 41. 41 says this: in making a decision about the voluntariness of a confession or admission, you should consider all of the evidence about the statement, including the circumstances under which the defendant may have made it. Factors to be considered in determining whether a confession or admission is voluntary includes the youth of the accused, and of course that's not here. Also, his or her lack of education or low intelligence, the lack of any advice of constitutional rights, the length of detention, the repeated and prolonged nature of questioning, and the use of physical punishment such as the deprivation of sleep or food. Now you have to understand something. The state has to prove to you by a preponderance of the evidence that what his confessions were, or what he talked about, were voluntary, right? Now what does that mean? That means in this case that they have to show you that it's more likely than not that his confession was not voluntary. Here's the problem. The people that are in the room talking to Mr. Davis at that particular point don't have his best interest at heart. You know what that includes? Mr. Higgins, the attorney. So you have a detective say, don't go with your attorney. Mr. Higgins is your attorney. And now here we are, having conversation after conversation after conversation after conversation. So in terms of the element of whether or not there's a lack of any advice of the constitutional rights, you have an attorney who's definitely not working on the side of Mr. Davis in that room, cajoling, pushing, reminding, directing what he's going to say to the people that are in that room.
We just don't want to deal with those problems that come along with Michael and Avatar. So I don't leave it back. Yeah.
So once again, you're hearing Greg Caden's voice on there, and he's telling Keffe or Mr. Davis the things that he thinks and the things that he thinks would be appropriate for Mr. Davis's best interest. Does that sound right to you? Or does that sound like the lack of any advice of constitutional rights? Now, in addition to that, here's the last part.
What this ultimately comes down to is how a lot of people, your life is your family. And when I say your family, I don't mean your extended family. I mean your brothers and your sisters and your wife and your kids. That's it. Anything beyond that, as far as we're concerned, is fair game. Kevin will work out his own deals. Speedy ain't got a lot on the table. I don't think that's going to be a problem. And we'll throw that one in. If that's what's important to you, we'll throw that one in. But besides that, and everything else is early in for us.
I just want to say this to me and Keith had the conversation.
You have a tinge of what we like to call the kind of unethical behavior we would never want from our police officers in this case. Now, in addition to that, what did we learn from Detective Long? Detective Long testified and basically said that, look, there are times when I left the room so that Mr. Higgins and who? Mr. Dupree or Detective Dupree can have conversations. How was that okay? Now, when we think about the way this is working out in terms of integrity, listen to the reports that were made in this case about Becker and Long and protecting their file. You also heard from the civilian investigator, Dorsey, who got in here and testified and said, hey, he also used material like, for instance, Kathy Scott's book with the autopsy photograph, and Mr. Dupree did not want to say this, but he did say this on the stand, that Caden had stolen the Tupac file.
Was there a problem at the Las Vegas Metropolitan Police Department of information related to your investigation being leaked publicly?
Well, I became aware that there may have been some information being leaked. I couldn't say who specifically was doing it, but I was becoming concerned to the point that in our office we had shelves behind, not behind my desk, but there were some shelves where a lot of the case files were stored. And once this case continued and the nature of who the victim was, especially when he passed away, there seemed to be a lot of interest in it, outside interest, especially with the media. And I became concerned about it, so I started locking my case files in my desk because I didn't want them to be available. Because I had left things on my desk, and a couple times I had found things different than when I left them, and it just bothered me. So that's why I locked them up.
Now, why is that important to you? It's to determine the quality of the information that you've received in this case, whether or not it's all of it, whether or not it's in terms of its integrity has been preserved. Now, the additional, was there still an interest in the murder of Tupac at the time that you took over the case? Meaning, was there media attention? Maybe not to the level it was in the beginning, but was there still issues with regards to access to the file and that kind of thing?
Yes, there was.
And
now I know where you're going.
Yeah, and what I mean by that initially is that even in Metro, was there any concerns on your part about unauthorized access to the file?
Not by me. I wasn't concerned, but my lieutenant had become concerned and wanted to sequester the file away from everybody else because there was a lot of people going in and looking. Very, very famous person.
And with regards to the going in and looking, can you describe to the jury what type of activity we're talking about here in terms of going in and looking?
I didn't do any investigation in this, but my lieutenant told me that people had been going in and being curious, looking at the file.
Did you at any point, was there any measures that was taken to preserve the safety and security of that file?
Yes.
What were those measures?
They locked down the file itself, which was the hard copy of the file. We used to, at that time, we were on a computer drive called the F drive, which turned out to be too small, and they later moved it to another drive because homicide just kept growing. So they changed the way I did my reports. I would hand them in, and they were secure.
Now, once again, this is the civilian investigator. Referring you back to your previous testimony with regards to Keffe Scott. Just for the jury's edification, Keffe Scott is not a detective.
Correct.
She is a reporter.
She was a journalist, yes.
She's a journalist, all right. And she wrote a book with regard to her information she had gathered as that journalist, right?
Correct.
Not her own investigation, but what she had heard on the street.
And from detectives that she talked to, yes.
Right. And so when she first published her book, fair to say what I'm holding up for you, and I want to make sure I'm accurate for the jury, this is the 3rd edition, right?
Okay.
Are you aware that Keffe Scott's first edition that was published was actually in 1997, a year after?
Something like that. It was very fast after the trial. I remember that.
And then once again, 2-year-old Greg Kagan leaves LAPD and takes the Tupac file with him?
From what I hear, something like to that effect.
Meaning he stole the file?
Something to that effect.
Now, in addition to that, he also took the Biggie file, right, with him when he left?
From what I hear, I've never seen him, but that's what I hear.
Okay. Now, one of the things that's the danger in this case has always been, just because we say something, is it true? Right? Now, like what Mr. Paul had said earlier about, the microphone, what you're holding in your hands right now that you can touch and see and feel is a fact, right? That pen, that piece of paper, the chair that you're sitting on. The Lakewood Mall incident is interesting to me. And the reason for that is because they're using this as sort of the triggering mechanism that starts a war in Compton between Southside Crips, Mob Pirate. The question you have to ask yourself is this.
Those tensions boiled over in the Lakewood Mall in the summer of 1996. There, you'll hear that Trayvon Lane, a member of the Mob Piru, associated with Death Row Records, was there with other members of Mob Piru in order to do some shopping. Lakewood Mall was a mall nearby Compton. You'll also hear that baby Lane Anderson, Orlando Anderson, the defendant's nephew, was there. Now, Trayvon Lane that day was wearing a chain with a Death Row medallion. And there was a fight that occurs between the Mob Piru group and the Southside Compton Crips. And at one point, that chain...
The fight that we're talking about was discussed by the man who got up here named Jared Rock. Remember him? He got up here and he talked about it. And he says that it was basically mayhem. And I want to make sure to say that we told Detective Log a more specific sort of thing that happened at the Lakewood Mall, right?
Yeah, I would say.
Yeah. Can you tell us, for instance, the location of where the fight took place?
Yeah, it was by Foot Locker.
By the Foot Locker.
Yeah.
In fact, they mentioned that the fight at the Foot Locker was so bad that they had to remodel it after the thing had gone down at the Lakewood Mall. Fair?
Yeah, it was turned into the World Foot Locker.
Right. You described it as mayhem that was occurring in that Foot Locker.
Yeah.
Okay. Now that's important. His testimony to you under oath is that, hey, this is what happened at the Lakewood Mall in the Foot Locker. Now here's the question, though. I mean, it's funny how we just immediately jump. And when we say, oh, Lakewood Mall incident, and we jump into it as actually being true, what proof do you have that it actually happened? What proof? Now, Detective Ladd, what does he say? We go back to the Lakewood Mall incident, right?
Sure.
Is the Lakewood Mall incident in your mind the sort of the definitive act in which the war is now declared between the mob Pyru and the Southside Crips?
That was the first incident that sparked this whole back and forth thing. Yes.
Now, let me ask you this. Did it really happen?
Yes.
Okay. Now, in your book, you identify it as happening at the Lakewood Mall,
Yes.
and it happened in a Foot Locker.
Yes.
Now, do you have any indication at all of a police report or a call for 911 to the area on a fight that occurs at the Lakewood Mall that day? No.
No.
Do you have indication at all from the security people at the mall where they would have written up a report that said, hey, we had an altercation here at the Lakewood Mall?
I don't think a report was generated by the security officer, no.
Okay. Now, fair to say, of course, there's been some description of that brawl being the kind of brawl that actually required Foot Locker to redo their entire inside because it just destroyed the inside. Do you recall anything like that?
I never heard anything like that. I just know there was a fight at the Foot Locker.
Right. You heard there was a fight, but you never made any effort, for instance, and it's not your job because it's Lakewood, right?
Correct.
But in essence, no verification that even Foot Locker was contacted to say, hey, did a fight break out over here on this particular day? Nothing like that.
Don't recall.
Okay. So in essence, what we have right now is what you had heard from people on the street as to what happened at this Lakewood Mall incident, right?
Yes.
Now, some people, I would assume, thought that the shooting of Tupac was in retaliation, or maybe the fight of Tupac and Orlando was in retaliation to what happened at Lakewood Mall. But as you're sitting there right now, you don't have any actual proof of the Lakewood Mall incident actually occurred.
No.
Okay. Once again, do not presume anything in this case. When someone says, hey, this happened, look for the evidence that supports it. Look for the facts, like you would with a microphone or a pen, that supports it. Now, we have Special Agent Lee, and what does he say as a member of the FBI? Can you tell us what facts you have to support that there was even a Lakewood incident that occurred?
I'm sorry. You're asking what facts?
Sure.
We have several witness statements.
Okay, so you have several witness statements. You are aware that there's allegedly, and according to what you write yourself, this was a couple weeks before the murder of Tupac Shakur. Marcus, who lived at the Southside Crips neighborhood, was in a mall by himself. A number of Blood Street gang members attacked Marcus and then began beating him. Orlando Anderson and then others approached the situation, observed what was happening, and then went to the aid of Marcus. They beat up the Blood gang members. That's what you wrote in your 302, right?
That's for true, man.
Yeah. Now, in terms of that information, did you ever go to the mall to verify that there was this thing that happened a couple weeks before the murder of Tupac Shakur, which would have been sometime in August of 1996? Did you ever do that?
No, I did not.
Now, in fairness to you, sir, Lakewood Mall and that area is governed by a police department. I don't know, is it Compton or is it the next one over? I'm not sure.
Yeah, it wouldn't have been Compton.
Okay. So whoever's the next one, did you ever at any point reach out to that police department and say, hey, can you get us the information on this so we can verify it before we put it into our 302 that a couple of weeks before the murder of Tupac Shakur there was a beating that took place? Did you ever do that?
Okay, so your statement regarding doing it before we put in that was information that was provided to us by Mr. Davis. So at that time, we're just recording what Mr. Davis is telling us.
Sure.
So this is a follow-up investigation on that.
Sure, but the state has now introduced this document as an exhibit for the jury to consider. So you're telling us that you can't verify the information in it?
I'm telling you what Mr. Davis told us.
Okay, but you cannot verify that information. You're telling us right now you didn't verify the information that he told you.
I didn't verify that specific event.
Okay. Do you know if your partner did?
I'm not sure.
Once again, we can talk all day and have statements made, but without facts, what are those statements? They're just words, right? So even the FBI agent can't tell you that that was a confirmed event that actually occurred, that was a triggering mechanism to a fight between Pirate Bloods and Southside Crips, can they? You don't have proof. So can it even exist? Now, when you think about it, you don't have any facts. So you start thinking. You start thinking, well, so many people have said it. So many people have said, oh, well, this Lakewood Mall incident has occurred. Your job as jurors is very difficult. You have to sit here and weigh the evidence. But what facts do you have of it? If something happened inside a Foot Locker, for instance, you would think that there would be a report filed, right, by the Foot Locker. Or an alternative, if the Foot Locker had damage caused to the inside of it, it would be an insurance claim, right? There would be some trail and information. Or even just the police showing up on scene. Now, the second one I wanted to talk a little bit about is this idea of Tupac, right? That my client describes how he first sees Tupac Shakur on the street.
There he is on that BMW, like Jay Carter, and brawling, Tupac, Tupac. We like, there you go. Made the U-turn. We wasn't supposed to pick you. This is one of the U-turn. They was in the middle lane. We just pulled up on the side and checked every car to see where they was.
So what directed your attention to him was some girl shouting at Tupac?
Tupac! He gave us up away. Otherwise, they would have got away. He all ran out. You out of you. Oh, they was like, there you go.
That's what he says. Now, what did you hear from Leonard Jefferson? He testified. He was there among the caravan. What does he say?
Were you running up to the park?
No.
And so when you ran up, Tupac, was he hanging out of the window or was he sitting in his chair?
He was sitting in his seat.
Okay. And when you have that conversation with him, of course, you're having a conversation and it's not like, I mean, you're not hearing people screaming out Tupac's name or anything like that.
No.
All right, he's present at the scene. This is what he recalls. Well, let's talk about somebody else. Somebody Ingrid Stokes. What did she say? She's in the vehicle that's right next to Tupac and Suge Knight's vehicle. And then, according to the testimony, she edges forward, and then the other vehicle pulls up on the next lane over. But what does she say about this Tupac thing? And when that was happening, did any of your people in your vehicle yell out, Tupac, anything like that?
Absolutely not.
Oh my gosh, it's Tupac.
No.
Okay. Now, during that time period, as you're over here behind Suge's vehicle or next to it, did you ever see, can you describe to me what Tupac was doing in the vehicle?
When we pulled up on the side of him and she was talking to Suge, he was relaxed, like sitting in the chair, sitting in the passenger seat, and Suge was relaxed talking to Lauren. Nothing, like there was no engagement.
Okay, so as you're sitting there and you pull up, Tupac was not hanging out the window and doing something out of the window?
Absolutely not, no.
Okay.
No.
His torso was not sitting on top of the window yelling to his fans, Tupac.
No, there was no fans around. They were just driving in the car, listening to music like we were.
All right. And once again, I want you to remember that, okay? My client says he sees him, and that's how he's able to recognize that it's Tupac, is because the noise and the person, hanging out of the window is Tupac. Now, in Mr. Davis's book, he puts in the book exactly how he describes what happens here. And what he says is, if you look at the book, after our pit stop at the liquor barn, we continued towards the carriage house. As we were driving, the two vehicles that were with us got caught at the traffic light, and we kept rolling. A few blocks down, we were sitting at the light, and who did we see? The death row caravan hit the corner of Tupac, hanging out of the window of a black luxury BMW, waving to his fans. People on the streets were screaming, Tupac, Tupac, we love you, Tupac. In unison, all of our heads turned. There them go right there. If Pac had not been hanging out of the window, we would have never seen him. Why is that important? Because we are taking his account, and what we're saying is, at this particular point, is that a fact or is it a fiction? That is obviously not what happened on that particular night, because you have eyewitnesses who say something completely different. But what the state wants you to do is take that book, like you would an affidavit or a promise at the bottom of an application for credit, and sign it saying that I attest this book being true and correct with regards to what he recalls. Now look at the facts of the Colville versus Flamingo. Mr. O'Kelly, Dean O'Kelly comes in and testifies that they found these bullet casings, and these were the cones. And I think somebody had counted the cones and realized that there was a discrepancy in the number. But the cones are set out. This right here, this Flamingo. That right there where the red lights are on top, that's cool. Now the picture, of course, is, technology is probably better now than it was back then. But in terms of what you're looking at on the screen, let's just look at it for what it is. How can my client see Tupac hanging out of the window screaming if he's sitting at the intersection? And you have to remember that Ingrid Stokes had testified and said that there are at least one car in front of Suge's car, if not two. So if the other individuals are on the other side and they're going to cross but they're waiting at the light, how can anyone see Tupac Shakur inside a BMW if no one's screaming Tupac, Tupac? Is that a fact? This is the testimony that you've heard from people. Those are facts that I'm showing you right now. In fact, if anything, when you look at that again to see how dark this area is, the lights are there, once again, but this is 11 o'clock at night or 10 o'clock at night. It's dark. This is their evidence. Now, Mr. Davis in his book writes and says, we were sitting at the light. He's sitting at the light waiting for a red light. Say he is. He would have to run that red light to go down the street on Flamingo, flip around, and come right back. Now, the other part of this, too, that just doesn't make any sense is when you look at it from the viewpoint of this picture, when you see that white vehicle that's right there, that would be basically Suge Knight's vehicle. The evidence alone, just on this, would indicate to you that Mr. Davis is not telling you the truth. Or in the alternative, he's not telling you a fact, he's telling you fiction as to how this all goes down on the night of September 7th, 1996. Now we're asking you to use your common sense, right? Don't leave it at the door, don't leave it at the courthouse steps. But when you think about Mr. Davis's statements, they all conflict. The only thing that doesn't conflict in terms of the statements is what we would like to say are historical facts. And let me tell you the reason, the difference here. Anyone ever seen the documentary called Titanic with Jack and Rose? Yeah, all right. So we've seen that. Well, I'm sorry, they say documentary. We've seen that movie. Now, do we know if Jack and Rose actually existed? The answer is no, we don't. However, we do know that the Titanic did strike an iceberg and sink. That's a historical fact in the middle of fiction. So in this particular case, yes, his statements conflict with one another. They conflict with the book and they conflict with the facts. And the only thing that we have is that we can agree on is that Tupac Shakur was shot and killed on September 7th, 1996 in Las Vegas, Nevada. Now, some of the additional information that you've heard from the discussions that Mr. Davis had with people in 2008 and 2009, he stated that he waited outside of 662 for 15 minutes. You recall that? Go back to your notes. But with regards to what's in the book, he says he waited in the parking lot for 90 minutes. Why is that important? Because there's uniformed Metro police officers sitting in the parking lot. You heard testimony from Reggie Wright Jr., who says Metro was guarding security from the door to the parking lot, and I had my own retired police officers off-duty police officers on the inside from the door going into the club, as well as Pirate Blood. One of the other things that's interesting about what is in the book, for instance, is when Mr. Davis says that he had a gun. When you read the book, and you have that opportunity, you can take that book and look through it. One of the things that's interesting to me is this idea that he sees Zip, and Zip is in the parking lot or in the valet area. So it says, while we were waiting for the valet to bring out our cars, this would be at the MGM, Zip seized the opportunity, called me over to his Benz. Zip was a big-time New York player, pimp and hustler, who used to come out to California to handle his business and kick it with us sometimes. As I walked up to the driver's side window, I noticed that the rapper, Foxy Brown, was in the vehicle or the car with Zip. So he instructed her to step out of the car and motioned me to jump in. Zip had a hidden compartment that he opened up, reached in, pulled out a black 40 Glock out. He turned to me and said, "It's time to get the money." Zip handed me the 17-shot pistol, which I promptly put down the back up waist of my pants. I hopped out of the car, held the door open for Foxy Brown to get back in, closed the door, and they pulled off. Just imagine and just use some common sense. Is the book basically saying that when you're a gangster in Compton, you can carry a gun whenever you want? And that when you're driving towards the state of Nevada and you see the sign that says, "Welcome to Nevada," you pull over at some type of locker and then deposit your firearms because you don't want to break a law in Nevada about carrying a firearm? If you are a legitimate gangster, do you have someone hand you a gun and say, "Hey, take this one gun and go and commit a murder"? Does that make sense to you? Now, in addition to that, one of the things that we've asked you to consider in terms of your weighing of the evidence goes back again to the idea of witnesses, their own recollections. You're here to give, whatever weight. I'm going to read the instruction again. The credibility and believability of a witness should be determined by his manner on the stand, his relationship to the parties, his fears, motives, interests, and feelings, his opportunity to have observed the matter to which he's testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. Now watch this. This is the state's offer.
You and Orlando and everyone else meets up, but you guys don't have any guns.
Who said that?
Well, it was in the book. Until Von Zip came in the picture.
All right, let's. I don't want to talk about that.
Okay, but it is in the book.
Okay, yeah. Let them read about it.
Okay, and I guess Foxy Brown was with Zip.
Now here's the question. Is that the reaction of a man who wrote his own book and knows the details of the book? Does that look like a guy who understands and knows that, yes, that actually did happen because I wrote it in my own book? That man, when that statement was made, looks over to the left, or he's looking over to his right. And I don't think he's looking with this idea that somehow he knows what's going on.
You and Orlando and everyone else meets up, but you guys don't have any guns.
Who said that?
Well, it was in the book. Until Von Zip came in the picture.
That's important because you have first-hand experience of a person who does not know his own book, or whatever the story was, whatever the fiction was that was inside that book. Does that sound like someone who wrote his own book when he's asking the question, who said that we didn't have guns? That is what you would use in terms of your common sense, in terms of weighing the evidence in this case. Now, another thing in the book is he talks a little bit about Ingrid's car. And this is what he says about it. He says, "When the shooting stopped, we broke out and the white Chrysler Supreme full of young ladies was following us. The window quickly got shot out, so they stopped. The interesting thing to me was all of them rough ass niggas they were supposed to have with them. None of them did a damn thing and tried to come after us. There were a lot of shots left off in both directions." Interesting part, right? The window quickly got shot out, so they stopped. Once again, he's supposed to be there. He's supposed to be at the scene. He's telling you firsthand knowledge of what happened. Well, let's take a look at the testimony. And so at some point when the shots were ringing out, you just immediately just gassed the car and made a right-hand turn on Cole.
Yeah, into the turning lane.
Okay. And your testimony here right now, for instance, is that the top was down, but you didn't see...
No, I was looking down because I was initiating changing my seat. So I would thank God I was all face down.
Okay. And when you pulled off and you made that right-hand turn, did anyone shoot at you?
Probably. I honestly don't know. There was a lot of gunshots.
Sure. Did any, after the event had occurred, did you ever observe any bullet holes in your vehicle?
There was no bullet hole in my vehicle.
Was there any shattered windshield as a result of anything happening on the scene?
No.
Okay. Fact or fiction, right? Yes, we understand that Tupac got shot in Las Vegas on September 7th, 1996. But outside of that, what facts do we have to support what's in this book? Now, in addition to that, Mr. Davis talks, or in the book, talks specifically about his vehicle. And what he says here is that, let's see here, had busted on some off-duty cops in Atlanta a few years earlier, so he wasn't scared to bust on top of it. By the time he rolled up, he had to know the person they had jumped on was in the casino was a Southside Crip, so they had been on high alert. When the shots settled, a couple people in our car had fragments and glass in their hair, and none of us had been hit. Once again, you're reading a book that is fiction and not fact, but the state wants you to believe that this is somehow a confession that he was there and present at the time of the shooting. Now, in addition to that, did you actually look at the actual cartridge casings themselves?
Yes, I looked all 7 side by side, and I screened them and then grouped them into one grouping, which represents one firearm.
Right. And as far as you recall or understand, that the cartridge casings were located at one scene, not multiple scenes.
I didn't look into the case notes. That's to try to keep our distance. We don't do any investigative work at the lab, so we don't want to bias our mind to what was. So I did not review any of the crime scene photos, any of the diagrams. I do not know. All I know is I have 7 cartridge cases. How do they group, and which ones to enter?
Okay, and so out of the 7, all of them look like they were fired from the same firearm.
Yes, they had similar visual characteristics, and I entered one, which I assigned as lab item 1.
I see. So no. Now, the reason why that's important is because now it indicates what's the physical evidence here, right? What is the fact? The fact is the cartridge casings, whoever shot from whatever gun it was only one gun that was the shooter, right? Whatever it was. Not multiple people shooting back and forth. Now, I guess the question is, once again, just like the lake with Mons, and we have to ask ourselves, was any of the people that we've talked about in the car? See, once again, facts, right? We're like, oh no, we know that at least Orlando was in the car. How do we know that? What facts have you guys taken down that says that they've proven that Orlando Anderson was even in the car? We presume, right, that there was a fight that occurs at the MGM, and that, you know, as a result, it has to be Orlando. But if Orlando was sitting right there in that chair, what proof do you have that Orlando Anderson was even in the car beyond a reasonable doubt? But no, what we do is we lump everybody into the equation. Now, one of the things that was done in this case were photo lineups, right? A tool that detectives use to help identify potential suspects. In this particular regard, the photo lineup that shows Terrence Brown, no one, as far as you know, no one identified Terrence Brown as being in a vehicle, even in Las Vegas on September 7, 1996.
Yeah, if Terrence Brown was in one of those photo lineups, then he wasn't identified, correct?
How about DeAndre Smith? Was he ever identified by anybody in a photo line, and his photo lineup as being present in Las Vegas, Nevada on September 7, 1996?
I don't recall anybody being identified in a photo lineup.
Once again, a tool for everyone to use. We don't have proof that even Orlando is in the vehicle. Now, here's the question you have to ask yourself. Is Davis, Smith, and Brown even in Las Vegas on September 7, 1996? Why is that important? Because we're presuming all this stuff. Yes, there's a book written, he says these interviews, but what actual proof do you have that Davis or Smith or Brown was even in Las Vegas? Now, here's the thing. We know that Orlando was, right? There's video of Orlando at the MGM. He gives his ID to a cop. We know he's here. But who else? What proof do you have beyond reasonable doubt? Now, the things that we would look for would be in the MGM surveillance. Anything in there that would spot a person that looks like Mr. Davis in a suit walking through the MGM. How about paperwork, receipts, things that would indicate that, hey, I bought some stuff here in Las Vegas, you know, something along those lines. How about phone records? Anything with regards to Mr. Davis, phone records to his home for maybe his his cell phone or maybe just a phone in the hotel room because we're talking about 1996. How about photographs? These people, when you go to a fight, you want to memorialize the moment with a photograph. What about something like that for Mr. Davis? And the ticket stub is important in this case. And the reason why that's important is because we're going to talk about the ticket stub and the search warrant. Now, the ticket stub is an exhibit that I have brought up. According to the testimony that you heard, this was found with Suge Knight at his home. This is with Detective Laddie. It said that this was obtained at Suge Knight's house. This is a ticket stub for the Selden versus Tyson fight for September 7th, 1996. Why would he have this ticket? Because it's important. It's an event, right? You go to the fight. You know where you don't find any evidence of this? In that guy's house. All right? Something as important as this or something as memorable as this, we don't find it there. Now, here's the thing, though, about it that's interesting. Compton PD does a search. And you recall, it was about 2 weeks after this event had occurred. They said, look, we went and did a search of all these homes. It's like 38 homes. You know the homes that they also hit as well? Mr. Davis's home. And Orlando Anderson's home. So let's look at that. This would be back in when you go back and look at it. But with regards to this address here, and I want to say this is 1405 South Burris. Write that down because that's Mr. Davis's address in this case. They look through it. There's the address, people that live there. And then what do? They find some information that they take with them. So you're going to have this document and go back there. This is a receipt for property taken from that house, and that was done on, right here. This was done on October 2nd, 1996, right? So they go in there. They're looking for stuff. Here's what they find. 3 LA cellular envelopes, bills and miscellaneous papers, 1 empty envelope addressed to the bank, a card, a hotel receipt. And they take that. But what does the evidence show you? What do the facts show you? They don't have that receipt. We don't know where it came from. We have no idea. You start jumping and you help the state out, you would say, oh, of course, it's from here in Las Vegas. Okay, where? When? How? We don't have any evidence, and this is based upon their search. They also searched the house next door. The house next door was technically vacant, but it was Orlando Anderson was in that house. And this is 1409 South Burris. And what do you find there? You find a letter from Excalibur Casino addressed to Orlando Anderson. But nothing else. No date, no reason, and we don't have the letter to show all of you. We also have an envelope addressed to Orlando Anderson. That's from that address. You also have miscellaneous bills addressed to Orlando Anderson. But you would think this would be important for you, right? To determine whether even Orlando Anderson was staying at the Excalibur on September 7th. We don't even have that. Now, in addition to that, what you also have as well is, let me just go back a little bit. 1997, another search is done of one of the places that Mr. Davis stays. And in that place, when he went in there, they're looking for information. It's, of course, for another investigation, but ultimately, at the end of the day, they're still wondering who, if maybe Mr. Davis was involved with the Tupac murder. And this is what they find in the receipts. And this was this would be the 27th of May, 1997, so a year later. They find the following. Money due bill for the Monte Carlo casino, right? This is what they have. This is what they do. How does that help you? It doesn't. There's no date. There's no time. There's nothing that would indicate that it has anything to do with the Tupac murder. But once again, this is them coming into your home or into his home and searching without any type of announcement. They're doing this as a surprise, and that's all they find with regards to Mr. Davis. Now, you have to understand that, as we sit here right now, the question is always going to be asked, why would he say these words? Well, obviously, it was because he wanted to protect himself, he wanted to protect his family, and he wanted to make money. So let's listen to what Mr. Dupree has to say about that.
In addition to that, we talked a little bit about the type of scenario that Mr. Davis is in, right?
he's being targeted as a potential suspect in a Biggie Smalls murder. You developed information about him being a drug dealer, right?
Yes.
And you had said, I think, how much time was he looking at? Life sentence?
I think so, yes.
Right, pretty heavy sentence, right?
Yes.
And so you had also targeted the idea, though, that it wasn't just him moving some large amount. It was people coming into his house, potentially his family. People could be arrested, his friends, for instance, that was part of that, and they all could go to prison, right?
I will say this. Mr. Davis took the hit for a lot of people in his family and his kids, his wife, but that's why he did a lot of the stuff he did. I will say that.
And I appreciate you saying that. And so in essence, he said, okay, this is all on me, I will take the hit for the family.
Yes.
Now, going back again to more facts. Mr. Davis says, or the book says, that he saw Suge, Snoop, Tupac, and a Rolls Royce on Friday at MGM. What proof do you have of that? Detective Long has an interview with my client in 2009.
Everybody knows the names, and you spend a couple days before the fight. Are there any incidents in Las Vegas prior to the fight? The Tyson fight?
No. We seen them, they had pulled over their Rolls Royces. The girl was out there. We seen them and all that.
Who'd you see?
It was Snoop, Tupac, and Suge. They had a black, white, and a red Rolls they pulled up in. Rolls Royces.
Where was this?
This at the MGM.
For the fight?
Yeah.
Okay.
And Mike Tyson then pulled up in them Bentleys. Worry, Mike Tyson, and what's his name? Don King. They pulled up in their Bentleys, and all the girls were having their Rolls Royces in their They looking like Hot Wheels. It was so pretty.
You remember anything about what Suge or Tupac were wearing when you saw them pull up? You remember it all? Okay, that's fine.
This was like the day before.
The day before the fight itself?
Yeah.
Okay. So there was a big entourage, girls running everywhere.
Yeah.
It was pretty good circus going on.
Yeah.
Las Vegas circus.
So, Malcolm Greenish had testified. What does he say? Tupac was not there on Friday. He shows up on the Saturday. So your testimony here today is that you drove into town with Tupac, Tupac's fiance, and somebody else in a Lexus.
Mm-hmm.
Is that a yes?
That's correct.
And that would have been, what day was that exactly? The day of the fight, the day before?
That was the day of the fight.
So, so you arrived into Las Vegas with the morning of Saturday? The fight's on Saturday?
It was late afternoon.
Okay. Why is that important? Once again, little tiny details that over time, when you weigh the credibility of the statements made by Mr. Davis to whoever, were never verified. You have to understand that as he's sitting there and having conversations with people, you know, the hardest thing about telling a lie isn't the lie itself. It's the first time you have to repeat the lie. Is trying to figure out, what did I say? What was I wearing? Where was I at? And who was I with? As you're going through the lie. Now, every lie after that, muscle memory. It gets a little bit easier when you start repeating the lie again. But that first lie, what we're talking about here is 2009, after the proffer of 2008. Now, one of the things that he also talks about is, where did this happen, right? He's telling in 2008, the group of people that's there, including the FBI, where he got shot. And then he talks about, what was off of Sunset and Flamingo. We know that that's not true because Sunset and Flamingo run parallel to one another, right? So, and then also he talks about, it just describes it in Death Row Chronicles about it being like a parade. Well, let's look at it.
We went up to the 626. They didn't show up. We waited about 15, 20 minutes. They didn't show up. So it's like, let's go get some liquor. We stopped at the liquor store. I got out the van and they had to jump in the Cadillac. Oh, Buster, this kid.
Where was the liquor store at?
It's that street. It's a highway. What's that big highway there?
Las Vegas Boulevard?
No, not that one. It's east of it.
That's the one that runs behind all the hotels.
Greg.
It may or may not be on there.
It's the intersection where they kill him.
It's east of this.
So that's all.
Yeah. It was, what's 7 of them or something?
Real close to the 62 club?
Yeah. It's a big highway. It's the Merlin Boulevard. One of them.
Yes, you guys go to the liquor store, you're tired of listening before you keep on, you jump into the Cadillac, and you go to the liquor store, you get out of the van, you jump into the Cadillac with Lane and guys, and then what?
You roll up, what was that? Is that Harmon?
There's a Harmon on there. Harmon Street's on there if you can see it. Should be a Harmon Street on there. Cool ball.
And where did he get shot at? On Harmon, did he? No, it's on this street in Harmon. The whole wall. We was, this, I think it's Merlin Parkway or something like that. Did they call it? Yeah. It's a little liquor store right there. Then we came up Harmon at the Las Vegas Boulevard. And shit. Here they coming at BMW, King Carter. And bros like, Tupac, Tupac. We like, there you go. Made a U-turn. We wasn't supposed to make you. This is one of the U-turn. They was in the middle lane. We just pulled up on the side and checked every car to see where they was.
With regards to Mr. Davis' statements.
Then Duane Davis decides that he's going to do public interviews regarding his role in the murder of Tupac Shakur.
So you ended up getting in the car with Baby Lane and them?
I got in the car with them, yeah. When we ran into them, we went up to the light on Sunset and Flamingo, and dude, we acted like he was in parade or something. That nigga in that BMW hanging out the window. Hey, it's Tupac, it's Tupac.
Sunset and Flamingo. Now, you have to ask yourself the question, if he's the man who commits the crime or is present during the murder of Tupac Shakur, doesn't sound like he knows where it's at. But let's look at this. This is the video that was shown to you by the documentary people that were doing the Death Row Chronicles. I want you to watch his reaction here.
I'm here, Cobalt, Flamingo, and this is the spot that changed my life forever. September 7th.
Now let me ask you this. Does that look like somebody who knows exactly where the spot was that it happened? Remember the testimony of the person that got up there? He said, oh yeah, we went and we asked him, going out to the area, what evidence do you have of that? He's standing on a corner, and if you look at it again, he's on this corner of Cobalt.
I'm here, Cobalt, Flamingo, and this is the spot that changed my life.
Right over the back of his shoulder is where the turn would have been made by Suge Knight and so forth to make that left. That's not a man that's pointing to the exact location at which the murder occurred. Now, why is that important for you? Because by this point, I mean, we're talking years later, information about where Tupac was shot and killed, the general location of it, the Cobalt area, that's what he was pointing to. He was never, you don't have any proof that he knew exactly where the murder was. Why is that important? Because you would think that's one thing you would remember is where it was when it happened.
I'm here, Cobalt.
I'm sorry, go back there again. Do it one more time.
I'm here, Cobalt, Flamingo, and this is the spot that changed my life forever. September 7th.
You know what would have been a better angle for this crew when they're doing their documentary? Would have been from the other corner. Right? You're sitting on that corner and you point backwards like, this is where the spot happens. This is where I was, this is where Suge was, this is where the next car was, and the next car. You get specific. You don't sit on the corner of Cobalt and Flamingo in some random corner to say, this is where my life changed. That's not how it works. You show people exactly where it happens. He never knew because he wasn't there. Now, in addition to that, what you find as well is the, one of the images from the state's exhibit in this case is the image here. Now, one of the things that was asked about multiple times from different people who were responding to the state subpoena is, you don't want to be here, right? You're responding to a subpoena. Well, why is that important? Because they were showing you that, hey, I don't want to come forward. I don't have time for this, but I get dragged into court, right? We heard from people that the state had asked about. But who are the people that should have shown up in this case? Detective Mogg. The main detective, right? The guy who pushes this over the goalposts and says, hey, now there's enough evidence to charge this case. Where's Detective Mogg? Could they have subpoenaed him? Sure. Did they do it in this case? How about Chuck Knight? They know where he's at. He's in custody. It's not like he's going anywhere. Why isn't he here to share his story with you? How about Foxy Brown? Now, Foxy Brown is an artist. She's not here. You saw parts of the book where they reference to Foxy Brown in it. Where is she at? This Big Meech of Detroit is another individual that's named in the book. So when you read the book, what you're going to find is Big Meech is one of the individuals in the van that they're driving, allegedly, right? They never go talk to Big Meech of Detroit. Where's he? And then this Yusuf Jah person. Who is that? And then once again, our disgraced LAPD detective, Greg Cady. Now, you have to understand how many people had eyes on this file. And it isn't just one or two people. We're talking different, highly qualified, professional organizations from the FBI to Metro to LAPD to Compton PD and even to Mike Dorsey, the Eager Beaver civilian investigator. Those guys are all looking at this file, and none of them verified any of the information that we're talking about here. How is that possible? How is that possible? And that's a problem in this case, when you presume that just because the state says something that it's true. Now, in addition to that, think about all the law enforcement tools that they have to their disposal. Wiretaps, phone records, bank records, business records, hotel records, digital forensic examinations of digital devices, fingerprints, DNA, surveillance videos, surveillance. They can do firearm and casing examinations, search warrants, DMV databases, criminal history databases, gang databases, photo lineups, and then I fell asleep. So I don't know how many more, but when you look at all the tools at their disposal, they have nothing in this case that says that that man was here in Las Vegas on September 7, 1996, with all of their tools. And once again, for some of us that may be a little bit younger, the idea behind this is, yeah, maybe some of that stuff wasn't around, like digital forensics examination. Sure. Maybe the DNA wasn't as good back then. But all the other stuff is still relevant. There's not one thing that says that Mr. Davis was in Las Vegas on the night of the shooting of Tupac Shakur. Now, one of the things we talked about was retaliation, right? And said, oh, this was retaliation. And Mr. Pernille over here said that that this was one of those things where retaliation was, key. And I think Mob James got up here and said, oh yeah, if this happened to me, this is what we would do. That night we knew who did it. Really? What proof do you have of that? Right? So what they're alleging is Mob James went hunting. I think that's what the state said. Mob James went hunting. How? How did they retaliate against these four individuals when they went back to Compton? So the analysis is, man gets jumped, right, at a casino, and then you shoot him to kill him. That person just happens to be Tupac Shakur, the crown prince of Death Row Records, the #1 rap artist in the world, and then nothing happens to those four individuals? Well, let's ask the question as to what happened with the four individuals that were allegedly in the vehicle, that somehow there's going to be retaliation. At the time, with Terrence Brown, you are aware that Terrence Brown actually dies in, 2015?
Yes.
Right. And when he dies, do you know how he dies?
Yes.
How did he die?
He was at a marijuana dispensary in Compton, and a robbery occurred, and he got killed during the robbery.
So, based upon the way he was murdered in that case, no indication that that was some type of retaliation for the murder of Tupac in 1996 or something?
No.
In addition to that, 1996, I apologize. With regards to DeAndre Smith, do you know when he passed?
2004, and he died of medical complication.
Right. And as far as you know, nothing that would have been associated with any type of retribution or revenge for the murder of Tupac Shakur.
Correct.
Now, Orlando is the one who passes away relatively quickly after the shooting.
Yes, approximately a year and a half.
Right. And in terms of how he passes, he was shot and killed?
Yes, you want me to tell you what happened?
Please.
Orlando Anderson was with his best friend Michael DeRoe. They were at a burger stand in Compton. And across the street from the burger stand, there was a car wash. Orlando Anderson recognized the people at the car wash. There was 3 people sitting in the car, and he recognized one of them that owed him money for some narcotics that he didn't pay him for. So Orlando Anderson took it upon himself, and he initiated the confrontation. He drove up to the car, and he exited with a gun. However, one of the persons in the other car, they had a gun too, so they had a shootout at the car wash. And then when the smoke cleared, Orlando Anderson was killed during the shootout, as well as 2 other people in the other car were killed.
And in terms of the 2 other people in the other vehicle, were they both Crips?
Yes.
So it wasn't a blood-on Crip sort of shootout?
No.
It was just over money and drugs?
Yes.
Where's the retaliation, guys? Where's the thing that says this was a gang thing, and as a result of Tupac fighting and, getting into altercation with Orlando Anderson that cost him his life, that somehow that in of itself is done, and no one goes after the 4 individuals that are allegedly in the car? Do you know why they didn't do that? It's because they weren't in the car. Because as you recall, Mob James' testimony up here, this man gets up here and he's Mob James. But he's the type of person, though, that you think, if he's impulsive on this stand, how do you think he was 30 years ago? You don't think he would have done something? If the word on the street was, it's these 4 guys, you don't think he would have done something? But no, these guys don't die at the hands of any of the Piru Bloods. Interesting, right? No retaliation. And in this case, with regard to Bing Lane, with Orlando Anderson, he sues Tupac's estate for injuries. What do you do? Why do you do that? Why do you get involved in a lawsuit if you're the guy who's the shooter and commits the crime? Why would you do that? And then you heard testimony that Suge Knight and Death Row Records pays him money. Why would you do that? You're Suge Knight, you're in the car, you narrowly missed death, and now you pay this guy money? This very fearsome man, Suge Knight, who's the type of person that allegedly even held Vanilla Ice over a balcony, right, to get the rights of something or another, pays this guy money? This powerful man of a $300 million company pays this guy money? How does that work? Now, this is where the common sense comes into play, doesn't it? Shooting of Suge Knight, murder of Tupac, and no retaliation. Tell me how that makes sense. Now, in addition to that, when we go through the questions, what evidence do you have to show that Tupac was even a gangster? I think we had testimony that says that he wasn't affiliated with a gang. He was on a death row label. Suge Knight was Mob Piru. And so as a result, maybe he was just hanging around with people who were. But do you have any evidence to show that he was actually a gang member with the Mob Piru? The answer would be no. So we can't presume that either. They haven't shown you proof of that. So as a result, there's no retaliation going on between anybody because there's no gang warfare going on between anybody. Lakewood Mall incident was not proven to you, nor does it exist because you don't have any proof of it. Now you have this idea that there's a gang war going on and no proof of that after the fact. Now, let's talk about this white Cadillac. The white Cadillac that shows up everywhere, right? Now the first time we hear of the white Cadillac is when Luxor Security tells Detective Becker basically that a white Cadillac shows up. and is at the rear of Suge and Tupac's caravan. So let's hear this.
The Angel Zavala.
Right.
Zavala. He was working as well. His recollection of the vehicles were there was a white Dodge Caravan, a black BMW Mercedes, and 2 other black vehicles. 2 white vehicles were also behind the group. Zavala said he thought the last car was a Cadillac or Buick with 4 black males. Was what he reported.
Right. That's correct.
Thank you, Judge. I have nothing further.
Okay. Any recross?
Just real quick, Detective Becker, with regards to that last line, the last line is that the last white vehicle was either a Cadillac or a Buick, right? So the Cadillac was a white Cadillac.
Correct. That's the way that's worded, yes.
All right.
Either a white Cadillac or Buick, yes.
All right, no further questions. And why is that important? Remember the timeline. Tupac gets into a fight with Orlando Anderson. Tupac, Suge Knight, and the rest of the Pirate Bloods leave, or Death Row Records, they leave MGM, and where do they go? To the Luxor. While at the Luxor, they get changed. While they're getting changed, they get picked up by Suge Knight and the Caravan. Now, from that point forward, at the Luxor, you've heard now that there is a white Cadillac that's in the Caravan, and they're picking up Tupac. Now, what happens is that Caravan does not go directly to 662. They go instead to Suge Knight's house, and it's a private community. And this is what Officer Hyde says. I'm going to turn your attention to the Suge Knight residence. Can you tell us what you actually did at the residence?
I was with another officer, and we were at a gate, and we basically stayed at the gate while an entourage of vehicles came through. Approximately 15 vehicles came through, and the last one being Suge Knight's.
Okay, now with regards to the entourage of vehicles, where did they go?
In through the gate. I never went in through the gate, so I didn't see where they went after they entered the gate.
Okay. And with regards to the vehicles that went in, did you recognize or give note of any of the vehicles that were in there?
The last one was Suge Knight's. It was a cream-colored Cadillac.
Did you hear that? Cream-colored Cadillac goes into Suge Knight's residence along with a long line of vehicles. This is right after they're at the Luxor. They picked up Tupac, and now the Caravan goes into Suge Knight's residence area. And it's a private community. So it's not like this Cadillac just happens to drive down the street. He's in a private community because he heard from that particular officer that he was not inside of the community. He was on the outside by the gate. Now here's additional testimony from this
Did you see the cream-colored Cadillac leave?
Yes. They all left.
Okay, when was that?
Close to 10 o'clock, I would say.
Okay.
Maybe 9:30-ish.
Okay. So now it's not like the cream-colored Cadillac or light-colored Cadillac or white-colored Cadillac, whatever you want to call it, parks itself at the some other residence in the community that Suge Knight lives. They all leave. That's important, right? Because in essence now that white Cadillac or that cream-colored Cadillac is, by all intents and purposes, by the actions, part of the Caravan. Now another sergeant that's there at the scene, he testifies and he says this about the color of the Cadillac. Now with regards to your recollection for that night, did you, what were the other vehicles that you remember entry into the residence area of Suge Knight and leaving the area of Suge Knight's residence?
Well, Suge and Tupac were there approximately 30 minutes, and they exited back out, followed by cream-colored Cadillac, compact vehicle that was occupied by 4 females.
Okay. So once again, you have law enforcement officers sitting there, and they're just taking casual notes of things. No one's understanding this. And 30 years later, we're now talking about a cream-colored Cadillac that goes in and out of Suge Knight's residence. Now let's keep going.
Oh, and when that white Cadillac left that guard gate, it was occupied by 2 black males as well.
Yes.
Okay. Not 2 white males, not a black male and a white male, 2 black males. And the question's asked about a white Cadillac, right? So light-colored Cadillac. let's just keep going. Just with regards to the last question that was asked by the signature officer, he says that it was a white Cadillac. It was either white or cream.
Yes.
Is that correct?
Yes.
That's what you wrote in your report.
Yes.
Thank you. Good for the Now, reports are important, right? Because this man would never have guessed in a gazillion years he'd be sitting on a witness stand 30 years later. What do you think he would have to do? He would have to refresh his recollection based upon what he wrote down in his report as a police officer, right? So thank goodness he had done that. Now, Malcolm Greenwich says he saw a light-colored white Cadillac right before Tupac is shot. Ingrid Stokes describes the Cadillac as whitish, Cadillac fleeing the area after the shooting. Let's hear what she says.
And then, did you see the color of the vehicle?
Yeah, so we almost hit the car. When we were trying to drive off, there was a car in the lane, that last lane, that was the turning lane, and it was a white four-door. Can't tell you what kind, but I just know it was like white-ish. And
Okay, so that's what she says is the color of the vehicle that was the shooter in this case. Now, Heidmeyer, you remember him? He was the guy that was the very well-dressed older gentleman that was from the Maxim Hotel, and he was a security guard. And this is what he describes when he goes through it.
Over the wall, what do you see?
I see a line of vehicles in the left straight lane on Flamingo heading east, and there's several vehicles. There was a white Dodge Stratus at the front, a black BMW behind it, another dark car, and I believe another car, and then there was a white Chevy Suburban behind that, and several more cars.
Okay, why is that important? Well, obviously he doesn't know how many cars. We've had Detective or Officer Height say there's 15 vehicles that leave Shook Knight's residence. But one of the things that you find out from what he's saying is that you don't have a description of a white Cadillac. And this is, remember how he's looking at the road, right? He hears shots. He runs over to where the parking structure is, and he looks out, and he's telling you what he sees. Because guess what's happening? Shook Knight's vehicle is making a U-turn. Everyone in that caravan is making a U-turn. So what he is seeing is after the shots are fired, right? There's no white Cadillac. Now, if it was somebody in the group, maybe somebody's mom was driving it, or another person, and it was all legit, where is it now? Where is that white Cadillac? We don't know. Let's keep going with that. So, crime scene analyst Dan Ford, what does he do? He documents the vehicles in the caravan when they are stopped. So as the vehicles go back down Koval, they make a left onto Las Vegas Boulevard, and then Suge stops the BMW in the intersection of Harmon and Las Vegas Boulevard. Crime scene analyst Dan Ford appears on scene, and this is what he documents. In his crime scene report, 1996 BMW, 1995 BMW, 96 Lexus, Mercedes-Benz, Dodge, and Dodge. No Cadillac. Now you have to ask yourself the question, why isn't there a Cadillac? Why isn't there a Cadillac? The testimony from the people that were there say that Cadillac drifts down from the back, drifts up to where the BMW is, and shots are fired. And that Cadillac was whitish, light, white, cream, whatever, and then takes off. Now, let me just finish up at this point. Here's my problem with what I just did there. Here's my problem. This is 30 years later. You don't have any detective who got up on the stand to testify and say, hey, we eliminated that theory. In fact, I don't think that theory's ever existed until such time as we took a look at it and realized, hey, we got a problem with this Cadillac. It pops up at the Luxor. It pops up at Reggie or at Shook Knight's residence. It pops up, and then all of a sudden it's gone. Why didn't detectives look into it? Once again, not your burden. Your burden is to see whether or not that guy has been proven beyond reasonable doubt to be present at the scene of the shooting. Now, Reggie Wright, what do you know about this guy? Ex-cop, new cop, and once again, this is one of the state's witnesses. He's a felon. This is their witness. What does he do? He pulls security from Tupac and Suge. Why would you do that? But in this case, he takes over a $300 million company with no paperwork. He just presumes it because, why? Suge gets in trouble for violating on probation, to which That guy, Reggie Wright, had testified and said, yeah, I knew that. And he's the main guy for the security. What does he get convicted of as a felon? Money laundering. What does he tell his people to do after the shooting occurs? Lie to Metro. Why is that important? Because what he also told you is, hey, I'm Shook's right-hand man. When you make a call, if you want to find Shook, call me, I'll get you Shook. He also is the guy who does all the logistical stuff, right? He's the guy that's at 662 and so forth. This is his testimony. Now, up until this point, you had developed into the person that if you wanted to get a hold of Shook, they would call you, right?
In the streets, meaning when we out and about. He had an office staff, assistants, Mr. Anderson and Mr. Tesfaye, Roy, that were in the office, but generally, if I call Shook, he'll pick up.
He had basically made himself into like the right-hand man for Shook Knight. Here's this. His job was to provide security for Tupac, right? This is what he says about that.
As the head of Right Way Security, which was contracted by Death Row Records, were you responsible for Tupac Shakur's security?
Yes, sir.
How did you handle Tupac Shakur's security?
Well, I had two guys that were primarily always assigned to him. One guy was a guy by the name of Keffe D, who was with him a lot at the beginning. Later on, towards the end, a gentleman by the name of Frank Alexander was the one that worked with him as well. And then I would always have additional guys, like Al Giddings is one of them, fill in for him when those guys wasn't available. Generally always had one security guard with him. After this particular song came out, in about May or June, we upped it to 2 security officers.
Now, you mentioned a particular song came out that changed how you handled Tupac Shakur's security. What song are you talking about?
It was a song called Hit 'Em Up.
And is it fair to say that in that song, Tupac is aggressively expressing his dislike for the members of Bad Boy Entertainment as well as other artists?
That's fair to say.
And as a result of that, you decided to change security for Tupac or increase it?
Well, I was a part of the discussion and ultimately had to approve it, but I'm sure Mr. Knight, possibly Mr. Shakur, and maybe the security officer that was primarily with them, we all agreed that he probably needed another guy with him.
Does that make sense? I mean, what he's saying there is like, hey, you know, one of his songs, one of Tupac's songs at that time was definitely geared to cause some reaction from other people hearing that song, and as a result there was some concern. And on the night of the fight, September 7th, 1996, how many people do you have in your notes were guarding Tupac on the night of the fight with all these people around? Now let's continue on with Reggie though. Let's figure out, you know, in terms of what he does here. You have Frank Alexander, you have Tupac, and no other bodyguards protecting Tupac that night.
Yeah, Mr. Kevin Heckey was supposed to attend, but he didn't. He wasn't there, and I didn't know that he hadn't shown up yet.
But you are aware at that particular point, Tupac was the most famous rapper almost in the entire world, if not the entire world, and you only assign one person and another person calls him sick?
He didn't call in sick, he just didn't show up. But, yeah, I mean, it wasn't unusual for Mr. Shakur to roll around with one guy and his outlaw guys.
But once again, you're telling us it's only Frank Alexander that's coming from your office, right?
That is correct.
And you also share with us that there's other people inside of 662 who are patting down the Mob James crew, but you can't send any more people over to be there for Tupac?
If I knew there was going to be an issue that eventually happened, of course I would have. I would have asked them to stay in the hotel.
Now,
if I knew what was going to happen.
You are aware that this was fight night, this was Mike Tyson, and that everyone in the world would show up to Las Vegas to be there for the fight, right?
Yeah.
There are so many people.
Yeah.
And in your opinion, only if you believe that Tupac was somehow going to get into a fight or something along those lines, would you have provided more than just the one person? I'm just asking for your clarification.
I would have had an army around him if I knew something like that was going to happen, or suspect something like that was going to happen. But the gentlemen that were with them and the ones that you seen kicking on Mr. Anderson, those are security as well.
That was whose security?
Death Row staff.
But once again, let me make sure I'm clear. You, at this particular point, only have one security guard with all these other people from, I don't know, from Death Row Records who are not security guards. They're all gangsters, mob type.
Yeah, I trust more than I trust my security. Yes.
So more than you would trust cops and off-duty cops and retired cops, you trust those mob Pyru guys?
I do personally.
Okay. What's the problem with that? When you are, first of all, you have a very important client, and his name happens to be Tupac Shakur, you have to understand his history, right? This wasn't the first time that Tupac had been shot at. He'd been shot at before. This was a violent sort of lifestyle that potentially he was, potentially going to be in danger of, and you put one guy on him, and then what you say and what you tell all of you is that, hey, and by the way, even though I run a security program with all these retired and off-duty police officers, I trust mob Pyru, gangsters and criminals, to do the job. Why? How? That makes no sense. So what he says is he says he has 20 to 25 people at 6. So you're sitting at the club and you don't know.
I wasn't sitting, but yeah.
Oh, well, whatever. I mean, I'm sure you're working, right? So you're working, and your concern is making sure the club passes, and that the club passes for Suge Knight. Even though his attorney's present, all these cops are on the outside, and you have the security proficiency of Mob James on the inside, right?
And about 25 to 30 of my guys.
And so once again, yes, 20 to 30 of your guys.
Correct, yeah.
Retired police officers or off-duty police officers.
Correct.
And they're all there.
Correct.
And I don't know if we want to chalk it up to bad business. I don't think this is bad business. At that particular point, what he's done is expose Tupac Shakur and Suge Knight to potential harm that occurred that night. You put into the other equation, of course, that guy became the right-hand man to Suge Knight. That Cadillac seemed to have a pretty good home at Suge Knight's residence, and what do you have? You have an issue, right? Because right now, with regards to everyone else that's here at 662, you have Metro on the outside.
I was James Roll. So, and James was with Suge at the beginning. And quite frankly, he might be a little upset that my guys kind of took a lot of their roles or their responsibilities.
Right. So on this particular night, there's actually Metropolitan police officers that were they hired by you to be on the outside?
Well, I would say Club 662 or under Mr. Khaleesi and the person that was running the club, under their direction. I knew they were going to be there, but I didn't speak to anyone from the police department to say, this is how much I'm going to be getting paid. I need you to do this. I just knew they were going to be working from the door.
It still does not ring true. And if you were a detective during that time period, what kind of investigation was done on Reggie Wright Jr.? What kind of investigation was done on Reggie Wright Jr. to see could he have been responsible for what happened here? I want you to take a look at the picture that was part of the exhibits in this case. And imagine, once again, this is Suge Knight's BMW. It is sitting on the third lane, and then you have two other lanes. The middle lane is occupied by Ingrid, who then moves up. A white or cream-colored Cadillac, depending on how he looks at it, rolls up in the next lane over, and shots ring out into that vehicle. Now, it's a moving target because the other vehicle is moving. Suge Knight's car is perfectly still. But the way that the bullets are grouped and the impact in this area indicates what? Whoever held that gun knew how to shoot it because of the grouping. Now here's the problem with that. Who was in that white Cadillac? That guy? That guy's responsible for this? Orlando Anderson is responsible for this? You have no proof. There is no evidence. There's nothing when you look at this picture and every other picture in this case, it says that Duane Davis or Nader Anderson or Dre or in the alternate Bubble Up, the man that's driving the vehicle, were ever there. What evidence do you have? But you have in very amazing grouping in this case from a white or tan Cadillac in this case. Now, one of the individuals that we've talked about is Greg Cady, right? He gets removed from the Biggie Smalls task force. He's escorted out the door with LAPD. He steals the file. We talked about that. He creates books, podcasts, and documentaries. That part is the last part is important. Why? Because that's how he's making his money nowadays. Now, in this case, we've talked a little bit about this idea of a shot caller. What evidence do we have that Duane Davis has ever called a shot in his life before the Tupac situation? Do you have anything about that? Do we have anything that he's ever called a shot after? And what proof do you have that he actually called the shooting death of Tupac? Once again, we jump to the conclusion. We say, oh, well, he had to have done it because he's the uncle of the nephew of the guy who got jumped. We can't put Armando in the car. We can't even put Davis in Las Vegas, but we're saying that he did it. Just look at the proof. If you have proof, your recollection's gone. But here's the technical matter. Clear about something here. In terms of your investigation in this case, did Keffe D ever order a hit on anybody before or after the shooting of Tupac Shakur?
Not that I know.
That's coming from Detective Ladd, right? Boots on the ground. He's in Compton. He's a Compton gang detective. And what does he tell you? I don't have any proof of that. I don't know. Now we talk about the 10-day war, and in that case, what Detective Ladd tells us is no one's ever charged in that case. Weird, right? People are shooting each other, and there's no indication that it's an actual Southside Crip versus Piru Blood war. In addition to that, what are the details here that we want to get out? First of all, the state's brought up this idea of the Chrysler Sebring. Here's what I'm going to tell you. 30 years later, or even at the time when the statement was made about the Chrysler Sebring, how many people knew the information in this case? You don't know. But I would presume, if you just follow what Mob James said, everyone knew everything there was to do with anything with this case. And when you follow what the detectives say, there were leaks everywhere with Metro in terms of their file. What information was sacrosanct? What information was kept in a vault that was buried 30 feet down, that had a double combination code, and a Rottweiler standing over the top of it? What information that no one would have had access to, that was leaked out through Metro's people that they were concerned about, or an alternative talked about on the streets? So this idea of a Chrysler Sebring, is that enough? Is that what you say? Definitely. That's it. That's the one thing. What we would like instead is when they searched his home, Davis's home, that you find something that maybe was one of the girls in the Chrysler's possession. That just happened to pop up. Now, I don't have anything to talk about. But a Chrysler Sebring, no. The 40 Glock. The states basically submit on this one, meaning that, hey, the information about a 40 Glock was pretty quick. You have to remember that people were looking at this, trying to get as much information as they can, any which way. So you have Kathy Scott who writes a book. You have all these people writing articles and all kinds of stuff back in those days. And as a result, any of this information was available because you had newspaper articles. We've looked at some of them over here. And then we talked about this Laker ticket, which I can't find. But the Laker ticket is important. And the reason why it's important is because in the book, Mr. Davis talks about meeting up with Suge Knight sometime later at a Lakers game. And they have a conversation. Weird, right? It's like this man allegedly just looked directly into Suge's eyes, and then shots ring out that kill Tupac, and then all of a sudden they're at a Laker game. Like somehow Kobe just kind of brought them together, and now they're back to being normal. That's not how this works. That doesn't make any sense. But the state finds a ticket that's a Laker ticket. Now here's the problem with that. In terms of let me get to the ticket here. When you think about the ticket in this case, go back again to my original problem. That's a Laker game ticket that allegedly my client held onto, which we don't even know if he was at the game. But look at this ticket by Suge Knight, the Tyson ticket. He has the ticket indicating that it was there. You know what would be a better case for them? If they had this ticket, right? If they found this ticket in Mr. Davis's home, this would be a better piece of evidence in this case. Now, we're also going to talk a little bit about the Coyote Cafe. There was some discussion with this young man who gets in here, and he's part of the security for MGM. And he talks a little bit about, the security and the video back then. But we get into a little bit of a scuffle over this idea of what was in the security report. What we did is we included the security report for you to look at. This is the security report. And in that report, an officer writes a report that says, on Sunday, August 7th, 1996, approximately 8:50, this officer was in the elevator core when I noticed a DMA wearing a sports jersey force his way past the officers at the North Key checkpoint by the Coyote Cafe. Why is this important? Because in the book, allegedly, Mr. Davis is waiting for his nephew at a cafe at the MGM. They don't name the cafe. They just say, we're waiting for him at the cafe because everyone had gone to different locations of the fight. Which, by the way, the book also says that he was sitting in the second row. Sitting in the second row of the Tyson fight, and so afterwards they're all going to meet up at the cafe. What the state will argue to you is what this description is indicating that he's trying to get into the cafe to be with his uncle. Does that look like that's what that means? Trying to force his way past the officers at the North Key checkpoint by the Coyote Cafe. The unidentified black male adult was questioned by myself and Officer Hornbaugh at the side of Coyote Cafe. DNA was very uncooperative on answering our questions. While questioning the DNA, he continually kept looking over his shoulders towards North Key checkpoints. It was seconds thereafter that I noticed a large group of BMAs forced their way through the North Key checkpoint. Now, it seems clear that whoever they were talking about, which we now know is Orlando Anderson, was running from that group of people, which we now know was Tupac and Shakur and the Death Row Records people. Does that show you anything at all that he was meeting up with his uncle after the fight? They're not trying to make it a point. I just want to make sure we're clear. Because in the book, it says the following. Sorry. After the match, we headed to the prearranged meeting place where we waited for about 15 minutes. Little by little, everybody started showing up except for my nephew. Then some people showed up except they saw some death row people jump on my nephew down by the casino. We came to find out later the same dude from the Lakewood Mall, which, once again, is this even true? Guy with his chain snatched was walking with Tupac when they saw Baby Lane at the lobby of the MGM. We rushed out of the cafe and went to find Baby Lane. Now, here's the question. What surveillance do you have for that? You remember the surveillance that they showed you when Orlando was talking to the police officers and so forth there? Do you ever see a bunch of people rush in there? That would have been nice, right? They would have seen the younger version of that guy running in 30 years before, running in to check up on his nephew. Look at the surveillance for yourself. Is that a fact? That's not proven. Just like everything else in the book. Now, finally, search warrant of Mr. Davis's home. 2023, his home gets searched, and they're looking for evidence. They're looking for evidence, and they take a whole bunch of stuff. Among the things that they take is, they take this binder, and once again, it's odd for a hardcore Crip dude to have this particular binder that they are saying that somehow contained information in there that indicated to them that he was responsible for Tupac's murder. This is what they are giving you. This is their evidence. In addition to that, they look through his iPads and computers, and I think we had Detective Gaddis testify to that and say, like, hey, we didn't look at any of that stuff, or there was no evidence that was found in those things. Why is that important? Because if you're actively working on a book, what are you doing? You're emailing back and forth, you're sending manuscripts to Davis, says, hey, read this, and he sends something back and says, hey, it wasn't white, it was cream-colored Cadillac, right? That kind of stuff. That's what would have happened. That's what they're looking for. They found nothing. That's a fact, right? In addition to that, they find the book, right? So the book is in the evidence, and you'll have an opportunity to go through the book. But you know what's interesting about the book as well? Is the part that we talked about. This is in the book. Although the authors and publisher have made every effort to ensure the accuracy and completeness of the information contained in this book, we assume no responsibility for errors, inaccuracies, omissions, or any inconsistency herein. Why is that important? When's the last time a book had that language in there? Typically, something like this would be if it's a historical sort of fiction, right? Well, you know, it's a book about a guy who's in the Gulf War, and he's a soldier, and he does soldier stuff, and that's a book about him. Yeah, the Gulf War was true, but him as a person is fictional. That's the same kind of level. And when you put that in a book, what are you telling the reader? We can't verify the information that's in the book. Now, we talked a little bit about the spelling of Keffe. Keffe is his childhood name. He couldn't pronounce Keith. So when he was a kid, it was Keffe, Keffe. And it's important, right? Because you would think that a man who just published a book, that he's very proud of, this book, right? That he would put up there, Keffe D, the book, right? Is that the spelling of his name? Now, what the state did is they said, hey, we couldn't verify the spelling of his name. Well, here's the thing. Here's the verification of his name. Let me show it to you real quick. They found inside of his home this jacket. And this is a jacket for, looks like Southside City of Compton. Right here. State's Exhibit 103. They took a picture of the front of that jacket, which is this one right here, right? So this is the front of the jacket. But when you look at the close-up picture of this, what you find is this. This is how Keffe spells his name. So even though we might pronounce it Keffe, it's spelled like this. Now, why is that important to you? Because if you just published a book, or if you're reviewing a book for the first time, and you're going through the manuscripts, the actual spelling of your name is probably the most immediate thing you pick out, especially when it's on the cover of the book, let alone inside of the book. Why is that also important? Because in this case, Keith, is also the treasurer of this organization. It's a lowrider organization. So this is a man that's paying attention. He's not just a guy who's a member who just gets his jacket and they realize, oops, we misspelled your name. This is a man who would have put the exact spelling of his name on his jacket the right way because he was a treasurer of the club. That's what that means. Why is that important? Because Keffe never saw this book, never read it, never reviewed it. So when he holds it up and he tells people, like, go buy the book, what's he trying to tell you? Go buy a book that's not verified, I don't know anything about, but I'm here to make money off of this book. So use your common sense. In addition to that, one of the other things as well that I just wanted to bring up is this picture here. This is State's Exhibit 151. There's a picture of P. Diddy with Zip Martin. You know what's interesting about this picture? Is how many times allegedly Davis saw Diddy, right? And it wasn't like in some like alleyway committing a crime or doing anything like that. He saw him in the back of the like the award ceremony for Soul Train Awards or whatever the case is. Where's his picture? Where is that guy's picture with Diddy? Just like Von Zip's picture with Diddy, right? Because you would think on some level you want to show off. You want to say, hey, this is my boy. Here I am with Puff Sean Combs. Where is his picture? It's because it didn't happen. Now, there is a quote that's not even Voltaire, by the way, but I think the quote fits, and that is, we live in a world, especially in our country, where freedom of speech is a right. We enjoy that as citizens and as people who live here in America. And here's the problem, right? There are times when we hear someone say something and we're like, oh, like we don't approve of it, I don't want to hear it. I may be triggered by that, I may be angry by that. But the problem is, though, at the end of the day, we will defend it. Because as Americans, that's what we would do, is defend people's rights. In this case, when the state closes and they just say, hey, this man basically said blood money, we don't even know what that means. Where is that from? How was that in context? You guys got to look at it. But when you throw blood money out there, what you're trying to incite is for you to get angry. is for you to say, hey, you know what? No, we're going to punish this guy for this. Voltaire basically says, look, I may not agree with what he said, but at the end of the day, we defend it. Now, once again, is there any proof to anything that he said? When you go back and deliberate, ask yourself the question, what is fact and what's fiction in this case? And finally, before I close, it's very difficult on a case like this when you have so much information. Maybe you're sitting here and you're logically going through it and realizing like, hey, we don't have it. But there's few of us that feel it in our bones. And we say to ourselves, no, he's got to have done it. There's no way this man would have just said this over and over again without it not being true. And that's fine. That's your feeling, and there's no way that anyone would disrespect you for feeling that way. But the problem is you have to ask yourself, if you're feeling that, what facts do you have to support how you feel? Because we can feel that. But whether or not it's proven beyond a reasonable doubt by the state is quite a different question. And that's the question you have to ask yourself in this case. And it's going to take some courage to say, you know what? I may feel this way, but there's no proof beyond reasonable doubt that Mr. Davis committed any crime in this case, let alone murder of Tupac Shakur. So if you keep asking yourself the question, you just keep lying over and over again, you keep telling the fiction, does that change it into a fact? No. You have to have supporting facts in order for a fiction to become a fact. So when I leave, state will get up in the rebuttal. They have the last say because they have the burden. They have to convince you that they have done their job, that they have shown you everything beyond a reasonable doubt. Sometimes some of these prosecutors, I don't think it's going to happen with Mr. DiGiacomo, but sometimes prosecutors will get up here, well, Mr. Samp said this, and Mr. Samp said that. Here's the thing. Whatever you recall is really what the facts are in this case. So even though I put up stuff on the screens, doesn't mean that that's what it is. It's your recollection. But in essence, when I was showing you things, it's basically what the facts are. So in essence, if you ever hear from Mr. DiGiacomo, oh, this is what Mr. Samp said, it's what the facts have shown you. That's all. And what facts do you have to show that that man was even in Las Vegas on the night of the shooting of Tupac Shakur? Or in the vehicle? When you go back and deliberate, we are confident we're going to come back with a verdict of not guilty for Mr. Davis. Because it's the only verdict that makes sense in this case. And it's the only verdict that has any facts. Thanks.
All right. Thank you, Mr. Sampt. As you've recently heard, because the state has the burden of proof, they are allowed to open and close the closing arguments. So at this time, I'm going to turn the floor over to Mr. DiGiacomo for his rebuttal closing argument.
Everything that happens in a courtroom in America.
Yes. Come on up. You may proceed.
As I was saying, a jury trial in America, in any courtroom, a jury trial in America is about the truth. That's ultimately the determination that the jury gets to make. What's the truth of the matter here? And you know, Mr. Palal said, and I won't try and not call him Mr. Perdue, but Mr. Palal said, you know, you started this case 2 weeks ago. Well, actually, no, you started it 3 weeks ago. Because during jury selection, there was as much going on, maybe at the time you didn't realize it. Do you remember Mr. Samp's theme during jury selection for a lot of you? It was like, what if you had a family member that you never thought would steal, got accused of stealing, and you know, you wouldn't believe it. You'd want to look at the evidence. You'd want to hear the witnesses. And almost to a juror, you say, yeah, but then I'd ask them, but if they told me they did it, I'd believe them, right? And what was our, or at least mine, more than Mr. Palal's, was this isn't a referendum. It's not a referendum on the Las Vegas Metropolitan Police Department. It's not even a referendum on the task force that was involved in this particular case. And it's not even a referendum about our decision in 2009 not to prosecute Mr. Davis. Because this case is not about provability. It is a slam dunk, absolutely, totally no defense to murder case. It's about admissibility, right? Because what happened in this case is in 2008, think about what you know from Detective Becker. You know from Detective Becker, well first, I'm going to back up. How about you know from Mob James that there's two people. And why is it those two people that they're hunting from the Southside Crips, right? Because the only person that Suge Knight probably knows in that car is Duane Davis. And the other guy got his ass beat on the MGM video. So that's the two names that they know, right? That's the only two names Mob James knows when he goes to go hunting. So Compton, by the morning of September 8th, 1996, one knows it's Southside and at least two of the people involved in this case. And then you have the search warrant and evidence. We didn't read it to you, but read the 10-day war search warrant and all of the violence that occurred and all of the information that was gathered by the end of October, or the end of the 10-day war really, but by October 2nd of 1996, the police know it's Southside. They just don't have a witness. It's CRI. Credible, reliable, or confidential, reliable informants, or whatever it is that the LAPD uses or Compton Police uses. By March of 1997, what does Brent Becker tell you? Brent Becker tells you, we know the four people in the car, and it just happens to be the same four people, he says, are in the car 11 years later. That is the evidence that you have in front of you, and his defense is, Mr. Schamp's defense is he lied, but that isn't his defense. You haven't heard one recantation of his 2008 proffer or the various versions that go thereafter. Why didn't we...
I'm sorry, may I approach?
Yes.
Think about all the pieces of evidence you have in this case, right? You have 1997 where E.D. Fall won't let him really answer a question about much. You have 2008, 2009, 2017 twice. You have 2019, the book. And I'll agree with Mr. Stamp. Most of it is garbage. You guys can read it. We didn't present you that. I'll explain to you why you got the book. But then what else did you learn? In 2023, this man was arrested. And he got on jail calls. And he repeatedly said things that indicated he told the truth. When he says, I didn't break the deal. Greg Kading broke the deal. What was the deal? The deal was to keep it confidential. And why was this a problem in 2009 for us? Because we have a recording where our detective is asked to step outside the room. We have a lawyer coaching the defendant to not say things that is going to get him in trouble. We have a task force officer who's sitting in there going, yeah, but be consistent. And there is this whole very weird conversation. What we don't know in 2009 is if even the 2009 statement is admissible in front of a jury. But certainly we don't have 2008. And whatever Greg Kading did, whether you like it, don't like it, cops write books. Whatever he did, he wasn't a signatory to the agreement. So in 2011 and 2012, when there's the book and the documentary that's published and this recording is released, legally, it didn't exist for the state of Nevada. You heard from Wade Lee. For me to use federal government evidence, I have to get a letter from the federal government to utilize it. What happens after that? Oh, 2018, Death Row Records. All right, this guy, sizzle reel. He says he's the last living witness. This is great. Wait till we see Death Row Records, and then what's published. Every viable admission that he makes in the public release of Death Row Records is from the 2008 recording. And what does E1 Entertainment do? Tell us we can't have the underlying records. We don't have it. We can't have it. All we have is Duane Davis's face on for some time, but most of the admissions. And now you know why, now that you've heard the underlying recordings. Because these documentarians are trying to tell the truth. But Mr. Davis's version of events doesn't match the facts in those two statements. And when you actually hear it, his first one, why does that break down? It's not because he's not wearing a suit. That first one breaks down because they get to the point where they want to talk to him about the murder. And he says, I haven't had enough time to talk to my lawyer about exactly the way I'm going to word this so I don't basically violate the terms of the proffer agreement or get the death penalty or get prosecuted by the state of Nevada. So 2018, we're sitting there. Nothing we can do. And then what happens is in 2019, he writes a book. And, you know, there's all this, we should have called Detective Mogg. What exactly was Detective Mogg going to be able, 30 years later, to corroborate specific facts that are named in this book? No. When Mr. Davis sat down and told the police in 2008, they already had corroborated it all. In his book, what he did was two things. Because we hadn't yet seen the underlying recordings, you know that, from 2017. At the end of his book, when you get there, he starts talking about S.A. Holiday. Who the heck is Special Agent Holiday? Who is this guy? Nobody knows who he is. Call up the federal government. Hey, did Duane Davis ever talk to Special Agent Holiday? Oh yeah, he was interviewed in 1998, 1999. And then after you get into them and look at those statements that he made in 1998 and 1999, you then realize, oh crap, that is what, in the beginning of the proffer, the statements he's allowed to review and make any corrections to. Where he says things like, no, I didn't see Reggie Wright at the Peterson Museum. That is what allowed the admissibility of all of these statements to come in. It's because when he wrote the book, he described his lawyer. He described conversations with his lawyer. He said, I did a proffer. And he said, I told the truth because I knew I couldn't lie. And look, Darren Dupree obviously was uncomfortable with the entire situation. And like I said, it's not a referendum on what the task force did. When they found out they were going to get information on Tupac Shakur, it would have been nice to get a phone call and say, hey, the guys who actually have jurisdiction on this case should probably be involved in this. But that's not what this case is about, right? Darren Dupree said Keffe D took the hit for his family. Explain to me what hit this guy took. He got caught with a gallon of PCP, a kilo of cocaine, should have gone to prison for life. He said, I know nothing about Biggie Smalls. They should have left it there, sent him to prison for life because he's the head of the Southside Crips. He's dangerous. Mr. Sam says he's never shot before. Yeah, his first criminal conviction is for shooting at a house. Read the book. He says, well, Mr. Sam says there's no evidence that he was involved in the retaliation. Really? Because in those statements that you heard here, he says the stupidest thing I ever did was hold a meeting and tell the youngsters, you take care of the young mob guys and we'll get the big guys. Right? That's what he's doing. Mr. Samp got up here and accused Reggie Wright of murder. Let me get this straight, because he only did little parts of this. So they go to the Luxor. There is a cream-colored Cadillac. I wonder how many cream-colored Cadillacs there are in all of Las Vegas. Or maybe it's a white Cadillac. Either one. I'm just going to call it a white Cadillac because it's less words. Right? And that white Cadillac then goes and is driven by Suge Knight when he drives into his residence with the caravan. And it's inside the residence for 30 minutes. When it leaves, Sergeant Mangum says, Suge Knight and Tupac are now in the BMW, and the last car out is the white Cadillac, and it's a 15-car chain. Right? There's only 6 cars caught at Harmon and the Boulevard. Right? But who's in that caravan? Idi Amin, with Frank Alexander and Yafula and everybody else. Are you telling me if the white Cadillac that Suge Knight's Cadillac shot Suge Knight? Well, first of all, are you kidding me that Suge Knight set this up? So Suge Knight's driving the vehicle. He's going to put himself in the line of fire to have Tupac shot when he catches a bullet in the head. That's the defense. The defense is Suge Knight did it. Oh, well, if Suge Knight didn't do it, well, then Reggie Wright did it because he wanted to kill Suge to take over Death Row Records. Really? So you're going to kill the guy who's making the most money for Death Row Records as you're trying to take it over? None of that makes sense. But what did Sergeant Mangum tell you? Right? He didn't know, and guess what? Weird. There was no question asked to Brent Becker about that portion of the investigation. But he looked at his report and he goes, oh yeah, look at that. All of the overtime officers, yeah, they're all here. Oh, look at this. There's the gate log with all the license plate for all the vehicles. You don't think that was all run down early on in the investigation? Of course it was. We didn't feel the need to call Brent Becker back from Texas to say Reggie Wright and Suge Knight didn't try and kill themselves. Right? So if it's not them, who is it? That's the question you have to ask yourself. Mr. Samp says that, it's involuntary, his statement, because he didn't have his dirty lawyer in the room, Edie Fall. And you know he's dirty, right? Because he's the guy who, according to everybody, pays $60,000 or receives the $60,000 and is representing Orlando Anderson for him to perjure himself at Suge's probation hearing. That guy should be the guy that the government says, yeah, we want you in the room for him. But more importantly, what did you hear in the recording that Mr. Samp just played you? Edie Fall represents Michael DeRoe. What does the defendant say about Michael DeRoe, the Reaper? That he was snitching on him. So Edie Fall couldn't have been the lawyer in the room. It wouldn't be legally appropriate in the least bit for Edie Fall to represent Duane Davis when he's representing Michael DeRoe, the guy who's providing information on Duane Davis. What else do you know? There's things in that book that are true, and there are things that are just giant lies. Mr. Davis says, Corey Edwards, C-Ray, ratted me out. Well, what do you know? 2006, he gave a statement to the task force. 2026, he gave a statement to Gaddis and Mogg. You heard about the efforts we went through. We blew up his house. We blew up his girlfriend's house on back-to-back days. We got a warrant out of a California court for him. But Mr. Davis tells you exactly what Corey Edwards said. He says Corey Edwards is in the van behind. Why are we working so hard to get Corey Edwards to this courtroom? Right? Oh, once again, I know the lawyers have said it. Pay very careful attention to that Dirt Rock and the Lakewood Mall thing. Because actually it's Mr. Samp saying that the fight was actually in the Foot Locker and that caused them to remodel. What Dirt Rock says is it was by the Foot Locker and then later they remodeled to the World Foot Locker. There's no description by Dirt Rock of the fight spilling in there and breaking up all the furniture. These are kids fighting in a mall. Is it shocking to you that the police weren't called? And look, I don't run security for the Lakewood Mall either. But read the search warrant in this case from October or September of 1996. There's all kinds of descriptions of this Lakewood Mall incident in that search warrant. What else does the defendant say? Defendant says, Corey Edwards started snitching on me the moment his neighbor got killed. Oh, shocking. Bobby Finch gets killed. Happens to be Corey Edwards' neighbors. Happens to look just like Corey Edwards. He's like, she calls Suge and tells him, I'm not part of this. I don't want to die over this. And the response from Mr. Sanft is, well, they never actually got to kill Mr. Davis and Orlando Anderson, so they must not be guilty, right? It must be some other Southsiders that there. Is there anybody in the world who doesn't think Orlando Anderson is the person that pulled the trigger on this thing, right? Bobby Ladd knows it because, just as Mob James explained, he's the Prince of Compton. He didn't just get beat down by Tupac. He got beat down by Tupac and Suge and Neckbone and Buntree and every one of those guys on video in Las Vegas. And I know there's this complaint about the surveillance video. Look at that surveillance video on a number of different issues. One of which is, maybe the most important of which is, the cameras are fixed and you can't see a darn thing unless the operator is following it. Yeah, they keep it on the victim for a short period of time, Orlando Anderson, and then they follow the suspects out. They didn't think at that moment to focus on where did the victim go after he left security, because the shooting doesn't happen for 2.5 hours later. So this is not modern day Las Vegas with the high definition cameras, right? Mr. Sanft tells you, oh, well, what facts are there that he's in the car? Well, as far back as 1998, he says that he's in Vegas. He's like, oh, well, there's no evidence he's in Vegas. But there's actually more than that. And he brought up the search warrant returns. And he says there's a hotel receipt taken out of the defendant's house, and there is a letter taken out. Now, sadly, Compton PD exists no longer, so those records as to exactly what was taken. But if you look at the Excalibur receipt in this case for Orlando Anderson, that receipt shows that he checked in on the 6th or 7th and checked out on the 8th. I think it's the 6th to the 8th. That isn't a letter from the MGM. What does Mr. Davis say? Well, the Excalibur. What does Mr. Davis say? Orlando stayed at the Excalibur because he had comp points from their, everybody knows their casino cards, right? So who's getting a letter for something like that? That letter allowed the police, and if you look, the search warrant's on October 2nd. On October 3rd is the facts from the Excalibur showing Orlando Anderson's room. And when you continue to look at that receipt, you will see that Detective Becker went through and he wrote down the hotel phone numbers that they're calling. And then you see hotel receipt as the other thing that's collected. And what do you have from this case, which is the MGM Corey Edwards hotel receipt. But that one is only from September 6th to September 7th. Corey Edwards didn't stay, or at least his room, did not stay at the Monte Carlo Saturday night. But he did stay there on Friday night. And if you look, his phone is calling the Excalibur about 1 o'clock in the afternoon the next day, on the 7th, the day of the homicide. But then you go back to the Excalibur receipt, and you look at it, and on the morning after the murder, September 8th of 1996, whoever's in Orlando Anderson's room is calling the Monte Carlo. There's somebody else from the group staying at the Monte Carlo. And what does the defendant say? We checked in under my wife's name, Paula Clemens. Right? Look at the search warrant where everybody's name. You can go down there to each of the hotels. Hey, can you tell me who stayed here, who stayed here? If the name is under Paula Clemens, you're never going to find it. And by the time he gives that up in 2008, the records are gone. There's no way to look to see the Paula Clemens stay there. But oddly enough, and this is completely oddly enough, I'll agree with Mr. Sanft, there was no probable cause to believe we were going to find this in Mr. Davis's house. But for some reason, along with a scrapbook that he keeps, now, that scrapbook's empty. But all of these things right here, he has a scrapbook. And when you say, well, maybe it's not a scrapbook of his greatest hits, well, it's everything about Tupac and Biggie in the beginning. And on the backside are pictures of his kids. This guy's scrapbooking his murder, for God's sake. But we find this, and it's a money due bill for the Monte Carlo casino. Ladd and Brennan, when you ask Ladd, hey, why did you collect this item? I know it's Compton, I know it's gone, but why would you collect that? Because it put Keffe D in Vegas on the time of the Tupac murder. What other reason is there to collect that particular piece of item? Nothing. There's no other reason to collect that. And you know already there has to be somebody else at the Monte Carlo, because why would Rashina be calling Orlando at the Monte Carlo in Paula Clemens' room? Like the defendant says, we went back and partied. Orlando stayed with us at the Monte Carlo. We know he came here with Rashina Smith. He even says Paula and Rashina are here. So who's in Orlando's room? Because Orlando ain't. But when she wakes up the next morning, Sunday morning, she's calling over to that Monte Carlo to talk to Orlando. That's why there's the communication back and forth between them. There are many small facts you could go through in this particular case. Little things like, 30 years later, Detective Ladd said this was found at Suge's house. Except for look at the search warrant from October of 1996. Suge's house wasn't searched. So this may have been found at Suge's house at some point in time, but it wasn't certainly from the October 2nd of 1996 case. Mr. Samp made a big deal about the girls yelling. And the suggestion, even from Mr. Palal, is it's the girls in the Sebring. But that's not what Mr. Davis actually says, right? Yeah, he said Herman one time and the Boulevard, but he meant Flamingo and the Boulevard. They're at the light, at the corner. There is a 15-car or more caravan that's left Suge's house, and by this time, you know it's at least 17, right? So randomly, even though nobody in the world knows that Tupac and Suge are in this car, both Mr. Jefferson and Ingrid Stokes somehow figured out that Tupac is in this vehicle and know to join the line. You don't think anybody on Las Vegas Boulevard on September 7th of 1996 yelled out Tupac's name? Maybe they don't remember it 30 years ago, but that's the corner that he says he hears Tupac's name being screamed out. Not all the way down the street at Cobalt and Flamingo. Then he has to do the U-turn. Then he has to go all the way down the caravan looking in which car is actually Tupac and Suge. And then he hands the gun back. Dre hesitates, Orlando takes it, and he shoots the gun. The argument from Mr. Samft is somehow don't believe a completely corroborated full confession to this case because he was looking at a life sentence. And because he was looking at a life sentence, my client made up this highly detailed story. This highly detailed story where in 1998, he says who's here in Vegas with him. 1999, he gives a little bit more. Yeah, we were going to kill him, but not till we get back to Compton. So he tells you his intent in 1999, right? And then in 2008, Mr. Davis tells a highly complicated story, one of which has Corey Edwards and Kevin Davis and now Tracy Sessions. Big Meech's name is in the book. It ain't anywhere in any of the statements, right? Tracy Sessions, Kevin Davis, his brother. Don't imagine he's given us much evidence. Tracy Sessions, dead. So Corey Edwards is the only guy left alive in the van behind them that he's originally in. And he says, we get to the 662, and Corey starts complaining about what? Suge's got the cops on the payroll. Suge could have the cops kill us. Well, how the hell do they know or believe that Suge has the Las Vegas Metropolitan Police Department on the payroll unless they showed up to 662 and saw a bunch of uniformed cops sitting there? And then how does he happen to know there just happens to be a liquor store at the corner of Flamingo and Maryland? This is a high-ranking drug dealer who comes to town on the Strip. What tourist knows where Maryland Parkway is, by the way? But if you look at exhibit number 2, number 1 is the one modern day, but exhibit number 2 is where the 662 is and the Monte Carlo. And guess what? The 662 is past Maryland Parkway. How does he know that little tiny fact? And he says, "Oh, well, so much has been out there in the public ether." Do we honestly think a guy who's dumb enough to write a book could keep this story straight this many times over? How does he in 2008 tell the most compelling version of events that is corroborated by every single piece of paper or every single other piece of evidence in this case? Tell me how it's possible he was able to do that. And then tell me, these guys didn't want to know about Tupac. They want to know about Biggie. So why did he tell some lie about Biggie Smalls? Explain that to me. Why doesn't he go, okay, let me tell you, here's what happens in the Biggie Smalls murder. If he's just going to make up a story about a murder, you might as well make it up for the jurisdiction that you're in front of, right? Why is he making this story up about this particular case? And then you ask yourself, the cops don't believe him. Well, the federal government not only didn't prosecute him, they signed him up as a confidential informant, flew him to New York, and sent him in. And yes, Zip had cancer, Zip eventually dies, he's out of the game, passes him off to his nephew, but what's the one thing you know from that? You know he knows Zip. Which means every single fact that the defendant says in this case is corroborated with but one thing. And that's who's in the car. That's the argument. The argument is, apparently we have to have a surveillance camera that shows him in the car. He has to be caught immediately thereafter in the car. This is 1996 technology, so I guess there's no cell phone records or anything else. So I guess if there was a cameraman on the corner of Koval and Flamingo, we could convict the guy. But since there's not, there's no facts in this case. It's absolutely ridiculous. Go and read his book if you want. You will not be smarter for it, let me tell you. But he tells 2 giant lies in the book. But he also tells you his reasoning for it. He is really, really, really upset that Greg Kading released that recording. Right, wrong, or indifferent. But, in the grand scheme of things, he got away with a life sentence on PCP and a kilo of cocaine, and he got away with a murder. So in the grand scheme of things, I know he's upset, but he shouldn't be out there profiting off a murder in our jurisdiction. That's not something he should be doing in response to Greg Kading, but that's what he wants to say. Basically, he wants to call Greg Kading out and say he's a dirty cop. Well, there's no evidence that he was a dirty cop. There's no evidence that Greg Kading did anything wrong. As a private citizen, he wrote a book like every other ex-cop who had a high-profile case. It didn't change anything about the nature of this case. It didn't change the evidence. It didn't change the admissibility of the statement. It was when he decided in 2019 to write a book and waive his confidentiality that the federal government said, you can use the evidence. And at that point, right, everybody had known. In Compton, early on, the original investigators in March of '97, the task force in 2008, and the Clark County District Attorney's Office in 2009, and we had to eat crow and allow a murderer to live in Henderson and not charge him because of the various things that happened in this case. But to suggest now that there is no evidence of his guilt, the defendant said on one of those social media clips, when you watch them, he literally says, I beat the streets, I beat the feds, and I beat cancer. And now he's trying to beat 12 of you. That's what's going on here. Mr. Davis is attempting to escape responsibility for a crime everybody knows he committed, even him, and he admits to it for 7-8 times over the course of 30 years, and there's no evidence contradicting that fact. End of the day, hold him accountable for the crime he committed. Thank you.
Thank you, Mr. DiGiacomo. At this time, we're going to swear in the officers to take charge of the jurors and alternate jurors. We'll need my JEA to come out. Randy will take the alternates, and Steve's will take.
I'll take the alternates.
Got it. All right, so we'll swear them in. We'll swear the two marshals, because we have two more. We can just use the marshals.
Okay.
Okay.
All right.
All right, we'll have them swear.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them nor speak to them yourself unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members. There are 16 of you in this case. 4 of you are going to serve as alternates. You are not discharged from jury service. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. Additionally, the admonition remains in place. You're not to talk to anybody about the case. You're not to look up anybody involved in the case. You're not to research the case on any way, not to go to Flamingo and Koval and check out the scene, etc. The alternate jurors in this case are as follows. Juror 13, Hartman. Juror 14, Pavlina. Juror the back door with this door with Marshal Spies. He will take you back to your vehicles. Additionally, he's going to get your names and numbers so that we can contact you if you're needed to come back, and we'll also let you know what the outcome of the case is. All right, the 12 of you are going to go back with Marshal Stevenson at this time to deliberate. Please rise for the jury, everyone. All right, for the record, the jury has exited the room. I just want to thank the attorneys for the dedication that they've given to this case so far and the respect they've shown to the process and to each other. If you would give your numbers to Jessica, we will contact you if we have a question, if we have a verdict. Other than that, we'll be in recess. All right, thank you, everyone. All right, good afternoon, ladies and gentlemen. We do have a verdict. Anything we need to address before bringing in the jury?
Not from the state.
No, Your Honor.
All right, please rise for the jury. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
You may be seated. Welcome back, ladies and gentlemen. Has the jury selected a foreperson in this matter?
Yes.
Who is the foreperson? All right, Ms. Foreperson, has the jury reached a verdict? Please hand it to my marshal. Will the clerk please, will the defendant and his attorneys please stand to receive the verdict? And the clerk will now read the verdict out.
District Court, Clark County, Nevada, State of Nevada versus Duane Davis, case number C23377407-1, Department 2. The verdict reads as follows. We, the jury in the above entitled case, find the defendant Duane Davis as follows. Count 1, murder with use of a deadly weapon. Guilty of first-degree murder with use of a deadly weapon, dated this 31st day of August 2026. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes.
Yes.
Does either party desire to have the jury polled?
Yes, Your Honor.
Okay, please poll.
Juror number 1, is this your verdict as read? Juror number 1, is this your verdict as read? Juror number 2, is this your verdict as read?
Yes.
Juror number 3, is this your verdict as read?
Yes.
Juror number 4, is this your verdict as read?
Yes.
Juror number 5, is this your verdict as read?
Yes.
Juror number 6, is this your verdict as read?
Yes.
Juror number 7, is this your verdict as read?
Yes.
Juror number 8, is this your verdict as read?
Yes.
Juror number 9, is this your verdict as read?
Yes.
Juror number 10, is this your verdict as read?
Yes.
Juror number 11, is this your verdict as read?
Yes.
And juror number 12, is this your verdict as read?
Yes.
Thank you. The clerk will now record the verdict in the minutes of the court. I want to thank you all for the time and attention
May we approach?
to this case.
May we approach?
Yes. Ladies and gentlemen, there's potentially a second part to this trial that you'll have to potentially deliberate on, as the attorneys reminded me. So at this time, I'm going to have you guys go back into the back. The attorneys are going to see if we will need to do this second part. I will inform you of any update and then come talk to you. So at this time, please rise for the jury. For the jury, for the record, the jury has exited the room. Do you need a few moments to discuss how we want to proceed
We
with
are
the second
ready to
part?
discuss with Mr. Shant and then also reach out to Detective Ladd. If they don't want to stipulate, we would suggest doing it by video. It's very short testimony that I think is not in dispute among the parties.
Okay.
And so just if we could give us a few minutes and
I can do
we'll
that.
let your marshal know.
Okay.
Thank you.
On record, back on record in State versus Davis, C377407. My understanding is that the state has a record to make.
Yes, Your Honor. Due to witness logistics, we are deciding to not proceed with the gang enhancement. Mr. Ladd was our witness for the gang expertise during the course of the trial. We think he would be able to prove up the gang enhancement as it would just be probably 10, 15 minutes for the testimony, but there are logistical issues on our end that prevents that from happening. So at this point, we will voluntarily dismiss the gang enhancement to the charge.
Okay. So then at this point, what needs to be done is setting the matter for sentencing. We'll refer the case to the Department of Parole and Probation, preparation of PSI. Set it down for sentencing on the following date.
That's October 13th at 10:30.
Given the jury's verdict at this time, I'm going to hold Mr. Davis with no bail. We'll be in recess.
Excuse me.
Yes, sir.
I would like to have my stuff back. The computers, all the phones, everything.
Okay.
And I would like to appeal this matter.
Of course, there will be an appeal, but that happens after sentencing. And then you can talk about evidence that needs to be returned.
Thank you.
Okay. I'm going to go talk to the jury real quick. If you guys want to come back, you're welcome to. Give me about 5 minutes, though.
Thank you.